Hey Charlotte County, this is Charlotte County COPWATCH, and I'd like to thank you for all your years of support through the years. As a result, this channel has grown and allowed me an equity partnership in carmarshal.com. Please take the time to check them out. They help you buy and sell your next car, even have a negotiating tool to save you from the hassle of haggling with multiple dealers. The link is in the description below. Please click and help support and give if you can too through PayPal or Patreon. Thanks again.
Good morning to everyone. My name is Glenn Siegel. I'm the Special Magistrate. I'll be deciding the cases today, and this is the Charlotte County Code Enforcement Special Magistrate hearing. There'll be some procedures, and I'll explain those to you as we get a little closer to actually hearing the cases. At this time, would each of you rise and join me for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. The next instruction I have is kind of important, so listen carefully. If you reasonably expect to give any testimony today in any of the cases, and I'm not referring to public comment, but the actual cases, would you please stand up? The clerk will administer you the oath.
Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? If so, answer, I do. Thank you.
Please be seated. That'll be the last time I make you stand up. Agenda item 4, the next code enforcement meeting will be scheduled for September 6th of 2017. Do we have all of the agenda changes now? Okay, we're getting a heads up on that.
7 owner.
Okay. I understand that on the affidavits we now have owner on case number 7
Yes.
and 20.
And 20.
Okay, I got 7 and 20 and 28. All right, that being said, we'll go to agenda item 6. Before I do that, I did forget. I want everybody to keep in mind that if you have a cell phone, if you'll put those on the silent mode or vibrating mode, that'd be great. Won't interrupt our proceedings. And keep in mind that this microphones in all of the chamber are constantly on or being actually televised, if you will, on Facebook, as I understand it. So be careful what you say. This is also a quasi-judicial hearing subject to the Florida Sunshine Act. I am required to report any of conflicts that I have, or if I have any knowledge of the matters that come before me, I have to recuse myself. I've reviewed the agenda prior to today, and I don't have any conflicts to report. All right, agenda item 7, citizen input. This is the portion of the hearing where you can approach the podium if you have comments on anything related to what we're doing. It's not evidence. I can't consider that in a case, but if you have something that you'd like to bring up, you're welcome to do so. We limit everybody to 3 minutes so that we're not here for an extended period of time just on that. So if anyone is interested in making a public comment, if you would raise your hand so I can see who's out there. Okay, we have 1, 2, 3 people in the back. Sir, would you approach in the white shirt? Good morning, sir. What is your name?
Jonathan Hutchinson.
Okay, and what have you got? Just you want to address?
I'll make this brief.
Sure.
It's in reference to 104 Broadmoor Lane.
Okay.
And I would just like to advise that he has covered up numerous cave-ins into the canal bank.
I'm sorry, go ahead. Dad didn't turn the mic on over there.
Not a problem. Anyway, I'd like to just advise that there has been numerous collapses into the canal behind 104 Broadmoor Lane, and that they have been covered. Numerous attempts have been made to cover that up, and that Mr. Luzzi has been encroaching on neighbors' properties and has used the excuse that the property lines, when they get to a certain point, go at a diagonal, and that he considers that his property. Also, I'd like to mention that the debris, the construction materials used are just garbage found in dumpsters and stuff, and just used as filler and then covered over with cement. And car tires were used along the edge of the canal through the hole from one side of the property to the other. Numerous, about 70 bags of cement have been dumped into the canal itself, and various photos have been taken of how it has sunk into the canal during the recent rains. Also, I'd like to point out that he has run electrical wires to a permanent surveillance structure on county right-of-way, and that on June 21st, a large portion of the backyard fell into the canal, resulting in a car tire filled with cement that weighed about 500 pounds being removed from the canal itself. And then after that incident, he took seaweed from the canal and covered up the area where it caved in. And just would like to make you aware of the numerous attempts to cover up the failures of the structure.
Okay.
And that he claims that county right-of-way he can use, even if it is on the other side of the property marker, that since it's county right-of-way, he has the right to use that and put whatever he wants on it on the opposite side of the property marker. Because it's county right-of-way, he claims that the neighbor does not own that property, so it's free use for him. So that's about all I have to say, and thank you for your time.
Thank you for your input. Who is next? Whoever wants to be next, if you'd approach the podium.
Hi, my name is Doug Newport.
Yes, sir. Good morning.
And I live at 102 Broadmoor Lane, which is a neighbor to Mr. Lutz, whose case is on. I think it's COD 1603730. I'm his neighbor, and we share a property line together. My concern is for my house value and for my responsibilities to Charlotte County and Rotunda. Because it's in Rotunda, I'm expected to take care of the property in back of my house, which is Charlotte County property. If you take the property line and extend it down from front to back down to the canal, you would see that he has a planter 2 foot into my property, a circular one. He has a straight one that comes over 2 foot, and he has a canal wall that continues 6 foot onto the Charlotte County property that I'm supposed to take care of. And when you look at the canal wall, it's 6 foot over, but then it comes up about 6 foot and goes back, so it forms a U. I guess you do that for support, but I would be expected to take care of it. Along with that wall, the fill that was used, I think, is questionable, and I don't know that compensatory storage of water was considered when filling in this whole bank area, because the water has to go someplace, and I don't think that was considered. I'm not sure who issued the permit, whether it was Charlotte County or Rotunda, or if one was issued for the work, but it shouldn't have been allowed to come over onto my property no matter what. I don't know if it was inspected after it was done or not, but it shouldn't have been over there. It should have been back inside of his, I believe. Late on the afternoon of May 24th of this year, Wednesday, Mr. Lutz, a lady who I don't know, and two neighbors from up the street were working furiously in a driving rain to put the bank back in order. He was in the canal standing, pushing against it to make it stand up. If this was to happen sometime in the future after he sold the house, and we're all going to sell it sometime, you got to sell sometime. Death catches up with us all. I would be expected to take care of that cave-in, which I don't think is fair, because it would be on my property, the part that fell in. It does raise a question, too. Did he come over 6 foot already? How far up and down Charlotte County property can he go before he stopped? You know, I don't know if he can go all the way up to house number 1 or not. I'm hoping that you can correct it so that the lower portion of my property is sloping like it's supposed to be and cleared out. Thank you.
You're quite welcome, sir. We had one more person? No? Okay. Well, we thank you for the input that you've provided with us, and we'll continue on with the next agenda item. We have unfinished business. We have none reported. Agenda item 8, other business, none. Takes us to Article 9, consent affidavits.
We have someone here for
6.
7, and 8. 6. And 25.
I apologize for the delay. We have a few more people that have shown up. All right, so on the agenda for Article 9, consent affidavits, we're going to 6 first?
Yeah.
All right, case number 6, COD 16-2942, Karen Martin. If you're hearing that matter, please approach the podium. Good morning. Let me just 2942. Oh, here I have it right here. The county's ready to proceed. Looks like we have code enforcement officer ready to go. I'll call you first witness.
Darcy
Nicolosi.
Sorry. Darcy Nicolosi, Certified Code Compliance Officer for Charlotte County. On June 12th, I did a reinspection of the property for the affidavit non-compliance, and there was outside storage on the driveway and around the house, so the first affidavit non-compliance was filed.
All righty. Anything further?
No.
All right.
Well, Miss Martin did come in and talk to me on July 10th, and she was upset that there was a affidavit on the property.
Okay. All right, Ms. Martin?
Hi. Darcy's been really good at working with me. We had a lot of problems because I was sick for 3 years with the double mastectomy, single mastectomy, my colon blown up, colon reattachment, and 90 other procedures, and approximately 10 trips to the hospital and emergency room. The objects on the driveway were just taken out of the back of my truck. It was a swing for a chair that somebody gave me and a wooden shutter thing. And I had just put them there 2 days earlier, and it was during that period where it was thundering and lightning for 20 days nonstop, and it was dangerous to be outside to move anything. They were picked up 2 days later, and I don't live in a deed-restricted community because there's a lot of projects I like to work on, and the driveway is the only place that's not wet, because the ground, especially at that time after 20 days of rain, was soaked. Here's the pictures of what Darcy had given me.
You want to show them to Mr.
The complaint was about these items, and they were in the back of my my truck, but a friend of mine passed away, and his sister was having a memorial service, and the rain started coming, so I rushed home. I took them out and threw them on the driveway so that I could take some of the tents I have, because I run a farmer's market, and threw them into the back and rushed them over to the event so they could have the memorial service outside. When I got back, it was thundering and lightning. It thundered and lightened for another 2 days. Then I picked it up and moved it into the backyard where it was supposed to go. And the other thing was that the grass was over a foot high, but as you can see in the pictures, the grass is not over a foot high. So Darcy's been really terrific in working with me. You know, I wish that the property was perfect, but with all the situations I've had over the past 3 years, being a single person, there's only so much I can do. So, but I don't really, you know, I understand where you guys are coming from, but that was just a couple items taken out of the back of my truck, set on the driveway for 2 days. Darcy just happened to come, like, I took it out on Saturday. She came on Monday. It was picked up by Wednesday night.
Now, these photographs, did you want me to put these into evidence, or? Because if
Whatever needs to
I won't be
happen.
able to give them back to you if I do that. That's why I'm asking.
Well, I can get some more from Darcy then.
We have no objection to place those in evidence, Your Honor.
Okay, I'll go ahead and place those into evidence.
I mean, I'm completely with you guys to make the place nice. That was an abandoned, pretty much a crackhead neighborhood where I spent time with the police chasing off the drug dealers. All the houses that were empty at the time, which were many, I maintained when I was healthy. I mowed all those yards. I took care of that whole neighborhood to make sure squatters didn't come in. So I take a lot of pride in the neighborhood. So it's not something that I wish that I was able to do more and keep everything perfect. But with the circumstances as they are, I mean, I'm buried in doctor bills. I'm buried in paperwork. I'm buried in 3 years of back stuff trying to take care of my own personal life. And those things were simply taken out of the back of my truck for a matter of days. And I do have things on the driveway because I like to work on stuff. I'm rebuilding bicycles for homeless people. I'm working on building bicycles for kids who don't have any bikes. I mean, that's why I bought the house where I bought it, so I could do those things. I had previously lived in Rotunda, and I understood that people in those areas wanted things like perfect. So, but, you know, the scope of code is meant for safety, you know, and for a neighborhood to look good. So I'm right on board with that, but I don't see how this would fit into that.
Anything further, ma'am?
That's all, Your Honor.
All right, for the record, those photographs offered by the respondent have been marked as Composite Exhibit A. Anything further from the county?
Nothing further, Your Honor.
Ms. Martin, the nature of these proceedings is kind of like a traffic ticket. You ran a stop sign 2 weeks ago and have not run a stop sign ever since. We're really focusing at that particular point in time where the violation apparently did exist.
Well, Your Honor, the violation being referred to is junk-like conditions, and those items, that swing chair cost $100, and that partition piece cost probably around $70. So that's not junk. Those are valuable items that were simply being worked on and taken out of a vehicle. I mean, they don't fit into junk-like conditions.
Ma'am, I understand your position on that, but my decision is going to be to affirm the affidavit of noncompliance.
Under what terms?
That I find specifically on the photographs you put into evidence that on June 12th, which is the date that the code enforcement officer testified that you were in violation. It's a past violation. It existed as of that date. Those are my specific finding. The affidavit is affirmed. Thank you, ma'am.
Under what term? Is it junk-like conditions? Is it?
Yes, ma'am.
Okay, that's not junk, though.
You know, we can argue that all day.
Okay,
but,
Your Honor.
Thank you.
Will I have an opportunity for appeal for these?
Yes, ma'am. I'll put it in the
Yeah, because I think I have to hire an attorney because it's just a little bit out of hand. I mean, I'm working on things in my driveway. That's all I'm doing.
Yes, ma'am. And listen, if you feel that my decision is wrong, I certainly would encourage you to do that. I'm not going to be offended if you appeal it. But I'll put it on the order here of what you have to do. So just read that carefully. And there's some time limitations on it. So
30 days, Your Honor.
kind of watch it, okay?
Yes, Your
And
Honor.
we'll get that mailed out to you. Thank you. Should I put the order in here, too?
Yeah. Just put everything in there and,
Okay. This would be
second.
All right, takes us to agenda item 7, COD 14928, Ryan Legan and Courtney Taylor. If you're here on that, please approach. Good morning, sir. How you doing?
I'm doing well. How are you?
Not bad. We're going to follow the same procedure as the lady before you. The county will go first, and then if you have any testimony or exhibits that or other evidence you want me to see, just make sure you call it to my attention, okay? Thank you, sir. County, ready to proceed?
Officer Roadhorst.
Good morning. My name is Gary Roadhorst, Certified Code Compliance Officer for Charlotte County. This case originally came before the board on August 6th of 2014. I conducted an inspection on June 7th, 2017, finding the permits are still expired in violation of the order. I'm requesting a fine in the amount of $50 with a total amount of $70 for the lien fees.
Anything further from the county at this time?
Nothing further, Your Honor.
Sir, you want to proceed, please?
Your Honor, I believe that we were here back in...
Your Honor, I don't mean to object, but you would request the witness state his name and address for the record, please?
Okay, I thought we did that. Okay, go ahead, please.
Ryan Legan, 22286 Midway Boulevard, Port Charlotte, Florida, 33952. I am one of the owners of the property.
Thank you, sir.
Thank you. I believe that we were back here in February where I was assessed a fine as well. So one of my major contentions on this entire thing is I asked the court at that time to give me some leniency and a little bit of more time than normal because of a financial situation and my work situation that does not allow me to take a bunch of time throughout the week to meet with inspectors, meet with people to come do work on my property and other things of that nature. I do show that within 4 months we're up for reinspection on that, which I understand that this body has to keep things moving in a sort of sense to make sure that these things are stayed on top of and everything else like that. I will note that about 80% of the work is complete with the property. The only things I have left is to move some electrical. I don't want to have an inspector come out and look at a work site that is not fully finished. But I do intend within the next couple of weeks to have somebody out to inspect the property. I have been working on this, and unfortunately for your inspectors, if they do ride by the property, most of the area that's in question is behind a locked fence. I do have an animal in the back who has leisure to get in and out as he will. So allowing somebody to get onto my property without me being there would not be beneficial for any party. So I do ask that that this court would entertain not imposing a fine, since it looks like this is now the 4th one that they would be imposing on the property in the form of a lien, which I don't believe is beneficial for my part, and it's simply a monetary issue for the county, and it's not really cost effective for the county to continue doing liens. I just ask for this court not to assess another lien on the property when I'm nearly done on this project. And I will be asking the county to, instead of me reopening this permit, I believe that I've opened this permit 3 times prior to, and I'm not going to be wasting the money to reapply for this permit to have it finalized.
Mm-hmm. When do you expect to have the remainder of the work done?
I expect to have the remainder of the work done no later than the end of September.
Thank you, sir. Anything else?
No, sir.
Anything further from the county?
Nothing further, Your Honor.
Based on the evidence and acknowledgement of the respondent, I'm going to have to affirm the violation. I'm optimistic that you'll get it done and completed, and this will be the last time we have to see you. I don't mind seeing you socially, but here it's not very pleasant to be up here, and certainly not where you're sitting. But if you've almost got this done, I kind of, as you said, need to keep this thing moving. So it's I'm going to affirm the $70 fine, and wish you good luck with that.
Thank you.
Thank you, sir.
agree.
Okay. All right, that takes us to agenda item 8, COD 152787 Hunt Development Partners. If you're hearing that, please approach. Good morning, sir. Your name and position with the company?
Good morning. Keith Hopkins, manager.
Okay. Thank you, sir. If you bear with me 1 second.
I'm sorry, ma'am?
Were you sworn in?
No, I was not, ma'am.
Okay,
Thank
thank you.
Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? If so, answer I do.
I do.
Thank you.
Thank you, sir. Mr. Hopkins, we're going to follow the same procedure as before, so if the county's ready to proceed with its first witness, we'll call them, and then if you have any evidence or testimony you want to provide, we'll cover that after he's...
Officer Roadhorst.
Good morning, Gary Rollehorst, Certified Code Compliance Officer for Charlotte County. This came before you on July 6th of 2016. I conducted an inspection on June 9th, 2017, finding the permit still had never been issued and had since expired on a non-issued status. The original order indicated a $100 fine with lien fees.
When did it expire?
The expiration on this was January 9th of 2017.
Thank you. Anything further from the county at this time?
Nothing further, Your Honor.
Yes, sir. Your turn.
Yes, I just, since I realized what was happening, I hadn't realized that the permit had not been taken care of. I've gone ahead and finally cajoled the contractor to reapply, open up the file, and has responded to all the energy efficient calculations and the as-built drawing that was, and the NOAs that were asked. So all that has been resubmitted now to the building department.
And who is the contractor?
Beata Builders. They're out of Lee County, which is part of the problem. So it's been, I live down there as well, and it's difficult to try to get anything to happen from any distance.
Sure. And what is the status of that?
So everything was resubmitted on July 31st. The two items of rejection were they needed the NOAs for the windows and the energy calc to make sure the AC was sufficient. And both of those, I have copies of that. That's been submitted, and it's all part of the file. I have that here, too, if you'd like to see.
And so when Officer Roadhorse came by on June 9th of this year, the permits hadn't been, you hadn't started that process at that point?
I had started the process of begging the contractor to refile, but that it's on me. Gary's been very good to deal with, and I understand, what the scope of his, this office is. So.
All right, then in Charlotte County versus Hunt Development Partners, LLC, my ruling will be is I'm going to affirm the affidavit. That's a $120 fine. Hopefully you'll get this back on course and then get the project finished.
Fair enough.
Okay.
Okay,
thank you, sir.
Now 20.
All right. We'll take us to agenda case 20, COD 161763, Gladys Perez. If you're here on that, please approach. Gladys Perez. Going once. Going twice. We checking on. All right. Okay. Apparently, there's a mix-up in staff with the who's here and who isn't. So I'll recall that case later with the en masse with the remainder. So that'll take us to agenda item 25, case 1792, Southeast Property Acquisitions. If you're here on that matter, please approach the podium. Okay. Southeast Property Acquisitions, if you're here. Good morning, sir. Your name and what is your relationship to Southeast Property Acquisitions?
Aaron Zelenskis, and I'm the general manager.
Okay, thank you, sir. We'll follow the same procedure. I'm sorry that I interrupted you.
Oh, I need to be sworn in. I wasn't here earlier.
Okay, thank you, sir.
Do you swear or affirm that the testimony you're about to give today is nothing but the truth, the whole truth?
I do.
Thank you.
Thank you, sir. County call first witness, please.
Ms. Leonard.
Rhonda Leonard, Certified Code Compliance Officer for Charlotte County. This case was brought to you on May the 3rd of this year. It had a multitude of violations for work that was done without permits, including an interior demolition, windows installed, doors installed, the rear enclosed porch demolished, which was not by them, that was previously, but still did not have a permit. Junk conditions, exposed wiring, damaged walls. There was a multitude of issues. Conducted the follow-up inspection on June 15th. They had applied for a permit, but it went into rejection. And at the same time, there was somebody there trying to install an air conditioning unit without a permit. So we filed the affidavits for a one-day fine. The permit has finally been issued just within the last week or so.
Thank you. Anything further from the county at this time?
Nothing further, Your Honor.
Sir, could you tell me what's going on here?
The contractor had an issue with the permit. They got it issued finally, and then now we're working. So we're about 4 weeks out from completion. So don't know what their problem was, but they got it fixed. So.
Well, if we go back to my order, let's see, that was entered May 3rd of this year, and on June 15th, the code enforcement officers testified. You heard that testimony.
Yes,
is she
sir.
correct?
Correct, sir.
Her testimony was accurate?
As far as I know, yes, sir.
Okay. Thank you, sir. All right, in Charlotte County versus Southeast Property Acquisition, COD 1792, I'll go ahead and affirm the affidavit as a $120 fine.
Yes, sir.
Hopefully get this worked out. And
yes, sir.
we don't have to see anything. Thank you for your appearance, sir. Okay, agenda item case 28. COD 17650, Brandon Keevan and Brandy DeBoe. Sir, your name?
Brandon Michael Keevan.
Okay, were you not sworn in there?
Oh, yes, I was. Sorry.
Okay. Then just give me 1 second, if you would, please. Okay. Okay. I understand in the affidavit we may have an address that needs to be corrected, and it should be 22075 Felton Avenue.
Yes.
Is that accurate?
Yes.
All right. All right. That having been said, we'll just I'll deem the affidavit admitted so that we're all talking about the same property. Okay. Thank you, sir. Please proceed.
Rhonda Leonard, Certified Code Compliance Officer, Charlotte County. This case was before you on May the 3rd of this year. Violations were no permit for a portable canopy, junk conditions, abandoned vehicle. I did the inspection on May the 22nd and found all of those issues remained. We went to abate the property on June the 13th. Mr. Keevan was there and was in the process of cleaning things up at that time, so we did not complete the abatement, but we are filing the one-day fine because it was not in compliance on the date it should have been.
All right. Anything further from the county at this time? Anything further from the county?
No, Your Honor.
All right, sir. You want to tell me what's going on?
Yeah, sure. First of all, she's saying that I have an inoperable vehicle on my property, which is false. The vehicle is very operable. It runs. I can drive it. I actually brought it here today to prove.
What vehicle is it?
It is a 2005 G35. It's an Infinity. Because it has a little front end damage to it, but it still drives everything else. But she's still saying that it's inoperable, which is very false on that end. The canopy, it was no longer after she even came back in May It was not up. That has been removed. The fence has been pulled a permit since I've been notified of that. There was a permit. And when she came to my house on June 3rd or 13th or whatever it was, there was a couple buckets that I was cleaning out my trailer while she showed up. And I removed them and put the stuff back.
Is it your testimony that the car's been operable all along?
Yes. Just because I park it beside my house doesn't mean it's not operable.
Anything further, sir?
Besides the other houses in the areas that I've seen in the last year and a half, hasn't been touched? No.
Thank you. Is there any response?
No response, Your Honor.
Oh, and one question. Is there a way that I can get the license number of hers?
I'm sorry?
Or badge number?
Oh, yes. You'll be able to get that. Just see the folks as soon as the hearing's concluded, okay?
Okay.
All right. All right, so based on the evidence, I'm not so sure about the vehicle being operable or not at the time that the property was re-inspected, but as to the other violations that existed as of the date of re-inspection, I'm going to affirm that affidavit for a $70 fine, sir.
Okay.
If you wish to appeal it, I'll put that in my order so that you know what to do.
Right.
Because I realize you disagree with me on that.
Oh, yeah.
Okay.
But I know it's a money thing, so I'll just pay it anyways.
Sure, then if you want to, just get together with, can somebody help them with her ID number?
Excuse me, Your Honor. Your Honor, it's the affidavit as amended with the changed address. You're affirming?
Yes, I'll affirm it as with the amended affidavit.
Okay, thank you.
Address on it. Thank you, sir.
Thank you.
Now we're going to go to A, and then new business.
Okay, well, I got to do the rest of the affidavits we've got. Yeah. Everybody. All right, counsel, we have everybody that was present for the affidavits.
That's my understanding, Your Honor. Maybe you want to make just a request to the public, just to make sure that there's nobody else here. Just want to make a request to the public, just to make sure there's nobody else here that we haven't.
Is anybody else here for the affidavit violation? Okay, there being no response, then I'll go ahead and affirm the remainder of the affidavits as stated, which will bring us to agenda item X, new business. Oh, A?
Mm-hmm.
Okay, I didn't realize somebody was here.
There isn't.
Oh, the DOH, okay.
Yeah, they're going to get the county.
All right, we'll go start with the agenda item A, Department of Health case 15451, Patricia Kinsey. If the county's ready to proceed, your first witness.
Officer Barnett.
Leslie needs to be sworn in.
Okay. Just
Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? If so, answer I do.
thank you. Please proceed.
Terry Barnett, Certified Code Enforcement Officer, Charlotte County. 773 Jarvis Street is Zone RSF 3.5. The owner of record is Patricia A. Nicely. The case was initiated on October 19, 2016, after receiving a complaint from the Department of Health that the owners were in violation of the inspection and pump out ordinance. I took a photograph of the property on March 15, 2017. The photograph fairly and accurately represents the conditions I observed. I would like to offer the photograph into evidence as County Composite Exhibit 1.
There being no opposition and no objection, it'll be marked and admitted as requested. Please proceed.
Staff had contact with the owner and explained how to correct the violation. The notice of violation was served in accordance with Florida Statute 162. July 31st, 2017, Department of Health verified via an email that this address is still not in compliance. This concludes my testimony, and now I'd like to introduce Leslie Beauchamp from the Department of Health.
Good morning.
Good morning.
Leslie Beauchamp, Supervisor for the Florida Department of Health. I'm the custodian of records for the DOH database. I reviewed the database for 773 Jarvis Street on August 1st and found that no permits pertaining to the pump out ordinance have been issued for this property.
Okay, and did you wish to offer the report into record into evidence?
Yes.
Okay.
Yes, Your Honor.
Okay. They'll be marked as County Composite Exhibit 2. Anything further from the county at this time?
Nothing further, Your Honor.
Thank you. Charlotte County versus Patricia Kinsey, DOH 15451, pertaining to the parcel located at 773 Jarvis Street, Northwest Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and we will,
Your Honor,
give the respondent 30 days from the date of this order to comply by having the septic tank pumped and inspected in accordance with the Charlotte County Code, and the failure to comply with any provisions of this order shall be punished by a fine of $50 a day for each day the violation is shown to exist past the time specified for compliance.
Thank you, Your Honor. That's our recommendation.
I cut you off the stage there for a minute.
That's okay.
And that is my order on that matter. Okay. All right, we'll take us to agenda item C, COD 163730, Luciano Luzzi. If you're here on that matter, please approach.
Mr. David. I'm Carrie Mack. Thank you. Good morning.
Good morning. How you doing?
Probably better than I will be when this is finished. Carrie Mack for Mr. Luciano Luzzi, the respondent in COD 163730.
Okay, so
if we can avoid some things, we might be able to. The part of this notice of violation that I received, that Mr. Luzzi brought me, is a 3-page document. And a part of the document is paragraph number 3 that says, you were previously notified of the violation of Charlotte County Codes 3-5-91, 3-6-21, and 3-9-32D by findings of fact, conclusions of law, and order dated April 9, 2009. And then Mr. David sent me a document with a letter dated June 6, 2017, certified copies that I'm assuming he intends to use today. And I don't object to him using them, but I don't think they apply. These documents are directed to Zoraida Ortiz, also known as Zoraida Ortiz Guerrero, also known as Zoraida Ortiz Guerrero Luzzi. That is not the respondent here. You want to see those again? Sure.
Yeah, is that from the fire on there?
Just so no one's taken by surprise.
Oh, and who is that person? Do you know?
Do I know?
Yes.
I know. I'm not a witness, but I know them.
Okay.
I can tell you that if the public records were searched, that Zoraida Ortiz is not the owner of this property.
Oh.
She may have been when that order, or whatever we're calling it, was issued in 2009. Is it 2009, Mr. David?
Yes. This is also, it's the owner is also known as Zoraida Ortiz Guerrero Luzzi, L-U-Z-I.
I think I read that.
Okay, I just want to make sure I had it in the record.
I read it out, but she's a
And
woman.
I've repeated it.
And my respondent is, I think you could take judicial notice, is not a woman.
Okay. Judicial notice will be taken.
Thank you.
We'll submit these to the record, Your Honor.
And I don't object, as I think I already said.
Mac, this is what counsel handed me, I presume.
Right, it was a letter, I think, Mr. Siegel, I think it was a letter sent to me, I'm sorry, I don't remember the date, June is what I recall, and attached, there were 2 documents attached.
That's what, I have a paper clip here that's consisting of an easement agreement and looks like a drawing.
Yeah, I think those are public record. I believe the OR book and page are at the top.
Yeah, that is
yeah,
correct.
so
Okay.
I'm not objecting to their admission, except I don't think they're relevant to this respondent. That's my point. Because it's a part of the violation, paragraph 3.
Okay.
So we're prepared to admit that Mr. Luzzi owns the property in question on Broadmoor, 104 Broadmoor Lane. We're prepared to admit that he did not obtain a right-of-way permit from the county engineering office. We're prepared to admit that he did obtain a residential modification application from Rotunda West Association. I have a copy of that if you want to see it. Mr. David, I left the card attached to it. We're prepared to admit that Mr. Luzzi went as required and as directed in this notice of violation to the Community Development Land Development Division at 18400 Murdoch Circle. I don't have a date, but I have a little receipt, so I'm not certain of the date. It was after the fact to apply for exactly what he's told to apply for in this notice. And he was not allowed to, they would not accept, I think that's the more proper way to say it, they would not accept his application. He then went, again, as the section 3621 says, now this would be an after-the-fact permit, okay? We agree with that. And he encountered, let's see, on when he went to the Community Development Department, he dealt with someone named Chip Haig, a certified floodplain manager, plans examiner.
Excuse me, Your Honor. I'm sorry to interrupt the esteemed counsel. Generally, we permit the county to proceed with its presentation, and then we have an opportunity for the respondent to speak. I know she's got rolling there pretty fast, so maybe we'll just follow our process and we can get to her.
The issue she's
Okay.
That's what I was trying to do.
admission
No problem.
that she's making, so
It's up to you, Your Honor.
That's what I was trying to do, Mr. Siegel. Thank you.
Please proceed.
So, thank you. So, when he was rejected at what I call step one, he went over to the county engineer's office. He was directed to Public Works right-of-way, I think probably in this place, because it's the same address. He encountered a Tony Sissel, C-I-S-S-E-L-L, and a Chris Perrin, P-E-R-I-N. And they looked in their computer, and something's in their computer, compliments of Miss Nicolosi over there, and they would not allow him to even complete the application.
All right, Ms. Mack, let me just stop you at this point. I'm just trying to cover the admissions that you were going to acknowledge. Are there any further? Because what you're talking about, I think counsel's correct that you're getting more into the defense, which we'll hear.
Well, all we were trying to say was that I was not trying to give evidence. I'm trying to avoid some issues.
Sure, that's what I was trying to do.
Yeah, this basically tells him that he can apply for an after-the-fact permit, and this is what he has to do. And he tried to do it, and he was rejected. That's all I'm trying to say. So these are allegations, and we're trying to say that this is what he's done and what he was not able to do to narrow those issues, as I think I said in the beginning. So.
Okay, thank you.
I'm finished.
Let's see what the county has to say. The county ready to proceed. Your first witness, please.
Officer Nicolosi.
Darcy Nicolosi, Certified Code Enforcement Officer for Charlotte County. The property in violation is located at 104 Broadmoor Lane and is zoned RS.
I can't hear the witness.
They're having trouble hearing.
The property in violation is located at 104 Broadmoor Lane, is zoned RSF5. The owner of record is Luciano Lucy. On December 2nd, 2016, I conducted an inspection, finding dirt laid around the bank area of the canal and the right-of-way. A review of the Charlotte County database found a right-of-way permit had not been issued for the work presently being done. The property previously was heard on April 1st, 2009 in front of the Code Enforcement Board for the same violations. The property was found in violation by the board. During the investigation, I took photographs of the property on November 18th, 2008, March 24th, 2009, December 2nd, 2016, and January 19th, 2017, March 3rd, 2017, April 19th, 2017, May 25th, 2017, June 1st, 2017, and July 26th, 2017. These photos fairly and accurately represent the conditions I observed. On May 30th, 2008, the county entered into agreement with the respondent to encroach on the county easement that included trees, shrubs, and a portion of a wooden walkway. On November 21st, 2011, the county entered into an agreement with the respondent to encroach with a 8x24 dock, tiered, retaining wall, and assorted landscaping, trees, and shrubs. I would like to offer the photographs, agreements, and copies of the original permits into evidence as County Composite Exhibit 1.
I object to anything prior to March 3rd, 2017 not relevant, and I object to anything prior to the time that the county can prove Mr. Luzzi owned the property.
Your Honor, the county's position would be that all of that evidence is fully relevant to this claim because the property was subject to that agreement and it was bound regardless of who the owner that's appearing today. I don't believe there's any legal basis to claim that a properly recorded agreement between the Charlotte County and the property owner, where the property owner agrees to take certain actions based on an agreement with the county in order to come into compliance with the county's code, is somehow obviated by the fact that the ownership changes. So as far as we're concerned, Your Honor, this goes back to 2009, and all of this evidence points to a fact of openly and notoriously violating the county's code.
The only thing we're missing is music.
Your Honor, I'd appreciate it if we would keep this civil, Your Honor.
The agreement and the consent to encroach on the county right-of-way has already been offered in evidence by the respondent. Okay.
I haven't marked that as, if at this time I'll go ahead and mark that exhibit, respondent's exhibit A, because I didn't put that formally into evidence at this point. So we'll take care of that.
My objection goes only to photographs prior to the violation that's alleged, which is March 3rd, 2017. And I thought I made that clear, but maybe I didn't.
No.
So that's my objection. I don't object to the recorded document.
Relevant evidence is any evidence that tends to move forward the proposition of the parties in the case. And, of course, this is a quasi-judicial hearing where the evidence rules are more relaxed. I'm going to go ahead and overrule the objection and admit the photographs as Composite County Exhibit Number 1. And then you can just make any argument that you have related to that, Ms. Mack. County ready to proceed?
Yes, Your Honor, we're ready.
The notice of violation was served in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance, reference the existing violations. On June 2nd, we received a request for continuance of the case from Attorney Carrie Mack's office. The case was continued till August hearing. On July 26th, I conducted the final inspection, finding conditions remained the same. A review of the database found a permit for the right-of-way had not been submitted. This concludes my testimony.
Is there anything further from the county at this time?
Nothing further, Your Honor.
Do I get to cross this witness?
If you'd like to.
I just, I'm used to a different set of rules.
Do you have cross-examination? We may do
Good.
so.
Okay. All right. So, Ms. Nicolosi, what'd you put in the computer that did not allow Mr. Luzzi to obtain a permit pursuant to the notice that was served by the county?
I didn't put anything in the computer. The only thing that's in the computer is my case.
So why was Mr. Luzzi not allowed to make an application for a permit?
I will refer that to Tony Sissel, who is here.
So you don't know? Is that your answer?
I'm not involved in the permit process for this case.
Okay. All right. So your answer is you don't know. All right. So is the notice of violation that we're here about that bears a date, well, I don't know if it does bear a date, but whatever the date of it is that somehow noticed or notified or flagged, or I'm not sure what the word is, about this property at 104 Broadmoor Lane? Is there some kind of notice to the employees or agents or representatives of the county that there's an action pending?
No, they would look in the computer if they were researching it and find the case, but there's nothing flagged on the case.
So you've not had any contact by Mr. Sissel. Is that Mr. Sissel? No, that's not Mr. Sissel sitting next to you, is it?
No. Mr. Sissel is sitting behind me.
I object to the form of the question.
Okay. I was just trying to identify the people. Did you have any conversation with Mr. Sissel about Mr. Luzzi attempting to apply for a permit as the notice of violation suggests?
It was,
It's just a yes or a no, ma'am.
yes, Mr. Sissel did tell me he was in.
Witness may answer the question as she sees fit, Your Honor.
I agree. I thought she was finished with it. Did you finish with your response?
Yes, it was meant, Mr. Sissel did mention to me that, yes, Mr. Lucy was in. That's all there was. I wasn't involved in the conversation.
Okay. All right. And how about Mr. Chris Perrin? Have you had any, according to his card, he is the permitting and licensing supervisor.
Chris Perrin is a lady.
Oh, okay.
And she's just the permitting licensing coordinator. She never mentioned it to me that she spoke with him.
Okay. Okay. Now, how about Chip Haig, the certified flood, according to his card at least, certified floodplain manager, plans examiner 2. Question is, do you have any conversation with Mr. Haig related to 104 Broadmoor Lane on or after March 3rd, 2017?
I have not discussed the case with him. No.
I'm going to overrule it. Just so both counsel know, my tendency is I want to hear the evidence. So if we have a relaxed set of rules, I'm not going to insist on the strict rules of evidence within bounds. Please proceed.
I don't have any other questions.
Okay. Any redirect from the county?
Officer Nicolosi, is this property in violation of the permit?
Yes.
Thank you. Nothing further, Your Honor.
We have anything further from the county at this time?
Nothing further, Your Honor.
Okay. Ms. Mack?
The notice of violation talks very specifically in section 3-6-21 about county specifications and the permit. So, Mr. Luzzi, will you kind of move up here a little bit?
Yeah.
Just say your name for the record.
My name is Luciano Luzzi.
Are you the owner of 104 Broadmoor in Rotunda West?
Yes, no.
Okay, and did you receive this notice of violation that I'm showing you, 3 pages?
No.
You didn't receive it? All right, we're going to get to harder questions later, so.
I don't remember.
Yes, you got this.
I got this.
Yes. Did you get this?
Yes.
Okay,
Yes,
all right.
yes.
Is this a copy of what you got? How about if I say it that way?
Yes,
Okay.
yes.
Did you read it? Just a yes or no, okay? Did you read
Yes.
it?
Yes.
Okay.
I don't understand it much.
Okay. Did you go to the Charlotte County government, to Public Works, to attempt to obtain a permit?
Yes.
And I'm going to show you this document.
Yeah.
Hold on just a second. Called an owner builder statement, disclosure statement. Is that your handwriting?
Yes.
2-page document?
Yes.
You want to take a look at that, sir?
Yes.
Thank you.
Ms. Pack, what was the date of that?
I don't know if it has a date. I'm sorry. I'll look again, but I don't know that it has a date. We'll stipulate it was after the notice. How's that? Okay?
What's after this?
What you got? I'm sorry?
Would you like to see the document, Your Honor? Would you like to see the document she's referring to, or it's up to you?
I'm sorry, I still can't hear
Would you like to see the document that Ms. Attorney Mack is referencing?
Are you intending to offer that into evidence?
I am. I just
Okay,
have
I'll
a couple of other questions, and because of language issues, just hold on a second, please, sir. I just want to be able to show it to Mr. Luzzi so he can see it, not just have to try and understand what I'm saying. Mr. Luzzi, you see this little number,
359.
this little number
Yes.
piece of paper here?
Yes.
Did they give that to you
Yes.
when you were there?
Yes.
And what was your understanding? When they called your number, you'd come up?
I come up and they
Okay.
they practically denied it.
Okay, well, hold on just a second. We're not up there yet. Okay? And where did you get this card from Chip Haig? Did you get it when you
Over
went
there
to
on the front desk.
do the permit? Okay. And were you allowed, was your permit application taken for consideration?
No.
I now offer that.
Any objection from the county?
No, Your Honor.
Okay, we'll go ahead and admit that as composite exhibit B for the respondent. I'm sorry, C.
All right. Now, Mr. Luzzi, I'm going to show you, oh, sorry, here you go, Mr. David.
Your Honor, this document is a copy of Article 2, Section 3-6-21 of the County Code, purports to be, attached with some business cards of county employees, Tony Sissel, Chris Perrin, and a copy of the application for construction permit document. No objection.
No objection. Did you wish to offer that into evidence?
Well, I will. I want to, again, because of language difficulties, I just want to be able to show it to Mr. Luzzi.
Please.
Mr. Luzzi, after you went to fill out the first application and it was not accepted, did you then go to the Public Works right-of-way department?
Yes.
And did you obtain this Article 2 document that consists of 2 pages?
Yes.
And did you encounter either one of these people whose cards, or did you just take them off the counter?
No. Mr. Tony Giselle, he was always on the phone.
Okay.
3 times before I hired you.
Okay.
And the other one, I took it from the counter. I'm supposed to see this person.
Okay.
He never came.
All right. So, were you permitted to fill out this application for the construction permit that is attached? Yes or just yes or no?
Yes, yes, yes. But Never was denied it.
Did they accept it?
No.
Okay.
At all.
Now we'd offer this.
Okay.
Does not bear date.
All right, that'll be, since there's no objection, we'll mark that as Respondent's Exhibit D, as in David. Please proceed.
Okay. Now, Mr. Luzzi, did you remove, we're assuming, by the way, for the record, Mr. Siegel, that the public comment is not being received as evidence. If it is, we're objecting because obviously we have been denied our right of cross-examination.
Well, I made that, I thought I made it clear at the beginning of it, but
You did.
Rest assured that it's not, I'm looking at what the evidence being
Okay.
presented.
I believe you did too, sir, but I just wanted to clarify it. All right. Mr. David. And Mr. David, I have another photo. I believe they both bear the same date. Mr. Luzzi?
Excuse me, Your Honor, these are two photographs dated May 24th, 2017.
Well, I agree. They are two photographs dated May 24th, 2017. Mr. Luzzi, in the one that's in my left hand, is that you?
Yes.
Okay, what are you doing?
I pull in what was the piling for the before structure of the whole entire deck I had.
Okay.
Yeah.
Did you pull this out of the canal?
Yes.
Okay, and then the second picture, what's in my right hand
Yes.
now, is that the same tire?
Yes.
Okay.
That was the corner.
Well, that was going to be my next question. Where is that located?
On the corner.
Okay, well, that's not going to help us any. Let's see if we can figure this out.
Yeah.
Mr. David, that's a picture of the entire property. If you don't object to that, it might help the hearing officer instead of these poison pen pictures we've got up here.
Your Honor, this purports to be a photograph of the property. I don't see a date on it,
This is the last one.
so I don't know what the probative value would be of it, since we don't know when it was taken.
Ms. McNeil.
Therefore, we'd object to have it entered into evidence.
Well, I was just showing it to him. I haven't attempted to enter it yet.
Okay.
Okay? Mr. Luzzi,
Yes.
you see this photograph?
Yes.
Okay, is that a photograph of the property at 104 Broadmoor Lane?
Yes.
In Rotunda?
Yes.
Did you take that photograph after March 3rd, 2017, or before?
Was after I took that tire and I resonated that corner.
Okay,
Maybe
so
2 days or 3 days after.
Okay, so is the answer to my question?
Yes.
Did you take the photograph after the violation was served on you?
Yes.
Now, how we'd offer it? Is it a true and accurate depiction of the property as it is?
Perfect.
As it was then and as it is today?
I said today too. Actually, the water level is higher because of the rain.
Can you just say yes or no?
Yes.
Thank you. Okay, we're going to offer this. Can I just walk up there? I don't know the protocol here.
That's, the council will bring it up.
I think we offered these as well.
No, you have not.
Oh, okay. That was my
Is this subject to your prior objection?
Yes, Your Honor.
It'll be, I'm going to go ahead and overrule the objection. I'll go ahead and admit it as we're up to E. And those two photographs?
I'm going to offer these as well. You don't need to touch it. It's okay.
Okay. Okay, there being no objection to the two photographs that we're talking about, the tire, we'll go ahead and admit those as composite exhibit F for the respondent. Please proceed.
Mr. Luzzi, did you engage an engineer?
Yes.
To, once you got this notice of violation from the county?
Yes.
And was the engineer L&T Engineering Group, Inc., specifically the Florida Professional Engineer, Florida PE number 73957, Patrick, I'm probably going to butcher his name, Mostyn, Mostyn. Did you engage him?
Yes.
And did you ask him to inspect your property, Mr. David, in
Yes.
light of the violation from the county?
Yes.
And did he do that on 3 separate occasions?
Yes.
And did he provide you with a report dated July 27, 2017?
Yes.
Your Honor, the document that's before me is dated July 27, 2017, directed to owner Luciano Luzzi. It's got the address of the 311 Rotunda West, Broadmoor, regarding landscaping in the right-of-way. Case number COD 1603730, to whom it may concern. Site visits and evaluations were made by L&T Engineering Group on May 27, 2017, June 20th, 2017, and July 20th, 2017. I'll read it into the records, no problem. It's just 2 paragraphs. We met with the owner, Mr. Luciano Luzzi, who explained to us to the extent and method of construction of the landscape material, landscape planters, landscape walls, and landings with stone and brick borders encroaching into the 100-foot right-of-way of Broadmoor Creek. See attached survey, which is not attached. L&T Engineering did not provide plans and details of the work for submittal and approval to Charlotte County Building and Zoning Department, nor did we provide construction observations within the right-of-way. However, based on conversations with Mr. Luciano and review of the existing conditions, it is my professional opinion that accepted means and methods were employed in the construction of the referenced items. In general, the site is stable and safe. However, there are a couple of landings that do not meet the exact requirements of the Florida Building Code. These landings are within inches of meeting the code. We have made several recommendations to Mr. Luzzi so that all the treads, risers, and landings meet the intent of the FPC. We've had an opportunity to review the project throughout the summer of 2017 rainy season, and all site slopes are stable. So our recommendation, Mr. Luciano, implement our instructions so that all landings meet the Florida Building Code, at which time we will certify the site. Patrick Mostyn, PE.
I do have the survey that's attached. I don't know how it got disattached. I'll find it.
We have no objection to entering that as evidence, Your Honor.
What I'm offering, Mr. Siegel, is the original signed by Mr. Mostyn with his professional engineer stamp.
All right. No objection.
We have no objection to entering into evidence, Your Honor.
That will be Exhibit G.
And as soon as I find the attachment, I'll
Any objection
attach
to
it.
supplementing?
I'm sorry.
Survey.
Your Honor, we do not object with supplementing with the
That's
survey.
fine. If you find it, Ms. Mack, just give a holler.
I'll find it. It's just not here with what I have. It's probably back in my briefcase, but
Okay.
I will find it. I know I have it because I saw it. That's why I thought it was attached. Okay. Mr. Luzzi, did you also engage the surveying firm of Divers, McLeod, and Kokomoor to survey your property?
Yes.
Did they do multiple surveys on your property when we learned further of the county's objections?
Yes.
All right. What I'm offering, Mr. Siegel and Mr. David, is the newest edition of the survey that also has the, so you'll recognize them unless you're a surveyor, the cutouts.
Ms. Mack, can you get a little closer? I know you're trying to explain that, but because we're televised, if you can get as close to the mic as you can.
Sure. That survey has got there may be 2 of them. They may be the same thing, is what I'm saying, Mr. David. I'm not sure about that. Together with the...
Your Honor, these documents speak for themselves. We don't have any objection to entering them.
Let me just see if they're the same. I think they are. It bears a date of, on the signature, 8/1/17.
It's the same.
This is the aerial photo, sir. You have it also taken by DMK.
Your Honor, this appears to be a printout from the Charlotte GIS system. Charlotte County GIS system. It's dated August 2, 2017. Would you like me to share this with the court?
Oh, I'm offering both of them, sir.
Okay, as a composite or separate?
No, separate, please.
Okay,
so we can refer to them.
Okay, their county's voiced no objection. The GIS will be Exhibit H.
Although not specific in the...
1 minute, Ms. Mack. Okay, you give me one page of the survey. That'll be marked as Exhibit I. Please
I
proceed.
determined they're the same. There just were two of them.
Okay, I just wanted
same thing. Yeah.
I wanted to catch up on marketing these.
Gotcha.
Marking these. I'll get it.
Okay. The notice of violation. Well, let me ask you this, Mr. Luzzi. Did you engage the services of L&T Engineering Group, Inc., the engineer, Mr. Mosden, and Barry McLeod of the surveyor at Divers McLeod and Kokomoor, in response to, in part, the notice of violation you received from the county?
Yes.
All right. Now, did you, were you informed that the county's objections included not only the fact that you didn't get a permit, at least from the county, but also that there was a elevation problem because of the structure that had been placed in the right-of-way? Did you learn that? Is that why you had the survey and the engineer? Because of the elevation complaint that the county gave you?
The county, when?
After you received the notice of violation.
Yes.
Okay. And
that one, yes.
did you obtain these documents, the survey and the opinion of the engineer, in order to have all of the documents that you would need, or at least that you believed you needed, to obtain this after-the-fact right-of-way permit?
Yes.
Now, did you live in the Rotunda West community, is that correct?
Yes.
And that's where the property is, it's in that Rotunda West?
Yes.
They have their deed restrictions, is that right?
Yes.
And did one of those deed restrictions or rules and regulations, I'm really not sure which, require you to obtain a permit or submit an application to the Rotunda West community?
Yes.
And did you do that?
I did it before I started to do anything.
Okay, and did they approve the permit?
Yes.
And somewhere I have a copy of that permit, so you'll forgive me.
Object to relevance.
And I'm going to offer it.
We'd object to that as not relevant to the case, Your Honor.
I don't know I necessarily disagree with that, but I'm going to go ahead and overrule the objection. I'll just take a look at it and consider it and give it whatever evidentiary weight.
So that it's,
Thank you, Your Honor.
So that it's further identified, it's dated 12/6/2016. Now, to the relevance objection, I know you said you would admit it and consider it. The relevance objection is that Mr. Luzzi did what he believed he had to do. So I think it is relevant. It was certainly long before this violation was noted. So to that extent, since you're offering it, I don't really need to say that, but you know, I can't help it.
I appreciate the supplement. Okay, we'll go ahead and mark that as Exhibit J for the respondent. Please proceed.
Now, Mr. Luzzi, were you prepared when you went to make these applications for the after-the-fact permit or permits? Were you prepared to pay the fees?
Yes.
And do what the county might have required you to do?
Yes.
Did anyone from the engineering I'm going to call it the engineering, Public Works Department. Did anybody come out and inspect your property or look at it in any way, to your knowledge?
No.
And other than Ms. Nicolosi, did anyone from the county come out and look at the structure?
Mrs. Nicolosi don't even knock my door. I don't know where she come from.
Okay. So is your answer that no one came?
No.
So let me ask the question first, okay?
Okay.
Did anyone from the county at all come out and look at your structure?
No.
Okay. Now, the structure that you replaced, did you take some photographs of the structure that you replaced?
Yes.
All right. And I'm going to show you a series of these photographs, sir. And all I want you to tell me is, did you take them? So is that a yes or no?
Yes.
Take these photos?
Yes.
Are they a photograph of the structure that existed?
Yes.
Hold on. You got to let me finish my question, okay? Are they photographs of the structure the way it existed prior to the time that you replaced it?
Yes.
And let's see how many there are. Thank you. I have a copy for you, Mr. David. They're not all glossy, unfortunately.
Your Honor, these are a series of undated photographs, and it's unclear to me what they are photographs of. There's no way to geographically reference where these are located. So pending authentication, we would object to entry as evidence.
I'll add another photograph. Make the 13. Mr. Lutzi, did you take those pictures that we're offering?
Same objection, Your Honor.
The 13 pictures?
Yes.
And what are they photographs of? Is this the rear of your property at 104 Broadmoor?
Yes.
Okay. And when did you take the photographs?
As soon as I come out to my house after 2 years.
Okay, we need a
It was
date.
last year, around October
Was
2016.
Was it before or after you applied for the Rotunda West permit?
Before.
Okay. And are these a true and accurate representation of the way the rear of your property looked before you undertook the structure that we're here about?
Yes.
I'm going to offer them.
Yeah.
Any further objection, counsel?
I'll restate the objection, Your Honor.
Okay, I'm going to go ahead and mark those as composite exhibit K, and then we'll admit those into evidence.
Thank you. You're admitting them?
Yes.
Thank you. Mr. Lutzi, when you applied for the permit with Rotunda West, I'm really not certain of what that organization is called, but that allowed you to get the permit, did you believe that that was meeting all the requirements that you had to meet?
Yes.
And when you found out that the county objected to the structure that you built, did you undertake to get the permits as you
Yes.
previously testified?
Right.
And did you believe that you were then at least making an effort to comply with the notice of violation that was delivered to you by attempting to comply with the notice that was given to you, Section 3-6-21, subparagraph B. Is that what you were attempting to comply with?
Yes, and I was denied it at the front desk.
We don't have anything else.
Any cross?
Except I need to go find that.
Yes, Your Honor. I just have a couple of questions. Mr. Lucy, would you step to the microphone, please?
Sure.
Ms. Mack, the cross-examination's proceeding. I tell you what, why don't we just wait till she gets back?
Okay.
So that
No problem.
she's in front of the mic. I'll go ahead and put these photos?
Yeah.
Okay, okay. I'm sorry. Thought you had it.
Let me know when you're ready, ma'am.
Go ahead.
Please proceed.
Mr. Lucy, did you apply for a permit for the work at issue in this violation from Charlotte County?
Can you repeat the question, rephrase it?
No problem. Did you apply for a permit with Charlotte County for the work that's shown in the photograph on the screen here, dated 7/26/17? It's dated July 26/17. See the photograph in front of us here on the screen?
Well, I tried.
Did you apply for a permit from Charlotte County for that work?
I tried.
You already stipulated that.
I stipulated.
Just so you can answer yes or no.
I don't.
Okay. Did you receive a permit for that work, Mr. Lutzi?
No, I just resurfaced what I had.
Did the work that was done on your property that's at issue in this hearing, did you pass inspections for that work?
What work are you talking about?
The work that as at issue on this notice of violation, did you receive a pass from the Charlotte County for that work? I'll restate. The construction work at issue in this notice of violation is displayed on the photograph in front of you on that screen. The question is, did that construction work pass inspections by Charlotte County?
Do you mean resurfacing what I just had, or what do you mean? Construction of what?
For the record, the photograph is dated July 26th.
Okay, Your Honor, I'll move on. Your Honor,
17.
I'm going to just go one more. I'll just say one more set of questions, Your Honor. These are the photographs that have been entered as.
Yes.
Yes. These photographs?
Yes.
You've authenticated them as photographs of your property?
Yes.
Do you know who installed this dock?
10 years ago.
Do you know who
Yes.
installed this dock?
Yeah.
Who installed this dock?
Was me?
Okay, thank you, Your Honor. Nothing further.
But was approved.
There's no question.
Your Honor, we have nothing further. We can have our recommendation whenever you're ready, Your Honor.
All right. What is the county's recommendation on this?
Your Honor, the county recommends the respondent be found in violation of the cited code sections listed in the notice of violation, that the magistrate enter a 2-year cease and desist order, that the property owner be granted 30 days from the date of this order to clear the zoning violations or thereafter face a fine of $50 per day for each violation that exists, that the respondent apply for the permits to bring the property into compliance and by passing all inspections in accordance with the Florida Building Code, or and that the county be permitted to abate the property in the event of noncompliance, and that the cost of abatement be added to any other costs, fines and costs. Sorry, Your Honor, please amend that, remove the abatement language. I'll restate it if you wish.
I'm sorry, you're going to remove.
We'd like to remove the abatement request. Thank you, Your Honor.
Okay, what I'm going to do, I've got a lot of evidence I better look and digest here. What I'm going to do is I'm going to take this case under advisement, Ms. Mack, and I will try to get something today. I will supplement. That was the supplement to the association's exhibit, the application.
That was the supplement to the engineer's
I got it. Okay.
letter report. that was, you'll see on the survey, Mr. Siegel, that the actual first survey was done on April 1st of 2017. And then there were amendments to it. So what the engineer attached was the original survey.
Okay, and for the record, Exhibit G will be supplemented according to the survey. As I said, I will take the matter under advisement. I just have a lot I've got to digest here.
Okay, I have something I want to say, if I may. Okay? I think the evidence has shown that Mr. Luzzi attempted to do what the county wants him to do. He attempted to get a permit. He attempted to get a permit exactly in compliance with the notice that was delivered to him, the document that we're here about, and he wasn't able to do it. You want to talk? He then went to the engineering department and further attempted, because that's what the notice says. You ultimately have to get the county engineer to say it's okay. All right. So he attempted to do that, and they wouldn't even take the application at that point. So it seems to me that if you adopt the recommendation of the county, then you would also have to. I don't know if you order the county to do anything, but whatever you do to the county, they would actually have to cooperate. So thus far, they haven't cooperated. My understanding, and I'm certainly not an expert in anything, much less these kinds of proceedings, my understanding is that an after-the-fact permit is allowed. Okay? There's been no testimony that the structure is otherwise unsound or causes any kind of a problem or anything. All we've heard about is no permit. That's it. That is the sum total of the evidence here. That's it. So I think that before you could order any type of other remedy other than requiring Mr. Luzzi to get a permit, which he's already tried to do months ago, not yesterday, not August 1st, not the month of July, but way before that, and he was denied, that there not be any kind of a recommendation related to the time that he tried, after the time that he attempted to get a permit and was denied. There's no reason. He wasn't even given a reason why he was denied. I mean, I think we know, but I don't think you want to hear speculation. He did everything that's reasonably required. He engaged a surveyor. He engaged an engineer. And to be frank with you, he might have done that for no reason, because we've not heard any evidence of anything related to the structure itself, other than it is there, and it's in the county's right of way. We admit that. And he didn't get a permit, and we admit that. That's it. That's what you've heard. Period. So why would we want to take down a structure if that's still a part of the recommendation? And I don't know, something was withdrawn, so I'm not sure if that's still a part of it. But if it is, why would we want to take down a structure for which no violations other than the failure to get a permit have been proved? So we would object to, we would ask the magistrate to use good common sense. And, you know, in the spirit of cooperation here, Mr. Luzzi's tried to do what the actual notice tells him he has to do. He did apply. They wouldn't accept it. You'll see, I think one of the documents is actually a completed application. They wouldn't even take the papers. There's no document that the county issued that says it's deficient in any way. They didn't ask him for money. He was prepared to pay whatever they wanted him to pay. And then he went to the engineering department, and conveniently, they said, oh, well, you have to go to the county first, just like he did. But he can't be ordered to do something that is impossible. He's tried to do it. And the engineering people wouldn't take the application either. So what is a citizen supposed to do? You know, he's mistaken. He went to Rotunda West. It's not like he didn't do anything. He went to Rotunda West. He got what he believed he needed. Now, it's not a defense to be wrong, okay? But he clearly was wrong. And we agree. We admit that. But then when he was notified, he tried to undertake those repairs. And except for, as Mr. Marsden says, except for some risers, I'm not even sure what those are, but whatever, the plans, the specs, the property they're all sound. The rain that we recently had, I think, was classified as a tropical storm. So we had a significant amount of rain. The engineer inspected the property after the rain. He saw no problems, no losing topography, no problems, nothing going into the canal. But of course, we haven't heard any testimony about that anyhow. So I would ask the magistrate to include in your order a requirement that the county cooperate with Mr. Lutzi to remove the violation, and the violation is that he didn't get a permit. That's the violation. Thank you.
Thank you. Anything from the county?
Your Honor, we, part of the recommendation from the county is that the applicant apply for the permit, which he acknowledged that he did not do. So we agree with counsel that he's in violation. I don't think there's any question about that. It is patently obvious that he is illegally constructed in the right-of-way. So your recommendation, or the recommendation of the county, is that he be required to make that application. And of course, the county will cooperate. You can order us to cooperate, but we'll cooperate anyway. And hopefully we can resolve this issue as soon as possible, because it's a clear and notorious violation of our code.
Thank you. As I said, I'll take this under advisement and advise ruling via order.
Okay, thank you.
Thank you.
Nice to meet you, Mr. Davis.
I'll just thank you. Aside.
Yeah.
Next case is going to be
Okay. All right. Sorry that took so long, folks, but we'll go to agenda item O, COD 17570, Linda Scott Irwin. If you're hearing that matter, please approach.
Good morning, Your Honor. Will Sunter on behalf of the respondent, Linda Scott Irwin, who will not be appearing today.
Thank you. All right. Is the county ready to proceed at this time?
Yes, Your Honor. Please proceed.
First witness.
My name is John Drown, Certified Code Compliance Officer for Charlotte County. 4228 Worcester Drive is zoned RSF 3.5, residential single family. The owner of record is Linda Scott Irwin. The case was initiated by Officer Williamson on March 2nd, 2017. When she conducted an inspection finding IPMC violations for exterior structure, including but not limited to protective treatment, roof and drainage, windows, door frames, and doors. Accessory structure in disrepair. Also noticed was trash, metal, other debris creating junk-like conditions and prohibited use. On March 8th, 2017, a courtesy letter was sent to the owner. On April 25th, 2017, a notice of violation was mailed, certified mail, to the owner of record. During the investigation, I took photos on July 17, 2017, and conducted a follow-up inspection, finding torn or missing screens, soffit fascia along with exterior is in disrepair. High grass and weeds exceeding 50% of the mowable area. The property was not secure, doors were open, and the trash was visible in the doorway. I took photos and posted a nuisance violation. On July 31st, 2017, I conducted the final inspection, finding that the violation still exists. I took photos. These photos fairly and accurately represent the conditions observed. I would like to offer these photographs and evidence as Charlotte County Exhibit Number 1. I have had no contact with the property owner. The notice of violation was served in accordance to Florida Statute 162. This concludes my testimony.
Thank you, Your Honor.
Any objections to me admitting those, Mr. Center?
No, no objection, Your Honor.
Those will be marked and admitted as requested. Any cross-examination or?
Yeah, just a very brief cross-examination because we have a problem with the homeowner not living in Charlotte County. You said you mailed out notice of the violation by certified mail. Do you have a copy of the return receipt requested? And I see it hasn't been entered into evidence.
Just for the record, I have it up here.
Okay.
Let me just identify it. Looks like it was signed by Linda Scott. I can't read it.
Okay.
On June 9th of 17.
I hadn't been able to see.
If you need it,
Okay, thank you. No further questions.
Thank you. Please proceed.
All right. Mrs. Irwin this is a somewhat unique case. Mrs. Irwin received this property from Mr. Irwin, who was the owner of the Impact University. There was probably about 8 years worth of litigation as to the ownership rights with regard to the property, whether it belonged to the estate of Jim Irwin or whether it belonged to Mrs. Irwin itself. During that time, there was a resident in occupation due to a agreement for deed, and over the years that person continued to live on the property, causing damage to the property, and Mrs. Irwin didn't have the ability to remedy it just because the question of title ownership was held in some controversy due to the litigation between the estate of James Irwin as well as Mrs. Irwin. Those resolutions came forward sometime in late 2015. We had to establish there was no normal note mortgage. We had to establish a note and mortgage on the property, which took some time to go ahead and have litigation with regard to that. Finally, once we've established ownership of the property, the person who was in there attempted to rent the property, ended up in late August, and I'm guessing I think it was late August 2016, Mrs. Irwin was finally able to get possession of the property by a writ of possession. Before that, all the time and any violations that took place beforehand and how the property got into the condition it was due to her inability to do anything. After she took possession of the property, Mrs. Irwin's had some health issues to be able to remedy that. She's lived in California. She's on 2 occasions attempted to hire contractors to go out to get to the property. Both the times those contractors have not done what they were supposed to do. We cannot argue that there are violations in place. It is not the goal of my client to allow this to take place. What we would ask the court to do is to allow her 60 days. She's come to the resolution. She has talked with the county that they have given her notice. She understands what the problems are, and she would like 60 days at the bare minimum to go ahead and fix the problem before any fines or levies being issued against the property, to give her the opportunity to go ahead and fix the problems that are on the property.
Anything further, Mr. Senator?
No, Your Honor.
Anything further from the county?
Nothing further, Your Honor.
Recommendation?
The county recommends the respondent be found in violation of cited code sections, that an order be entered for a 2-year cease and desist order be entered against any future violations, that the respondent be given 30 days from the date of this order to clear the zoning violations and bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $50 per day for each violation that exists, and that the county be permitted to abate the property in the event of noncompliance and the cost of the abatement to be added to fines and costs.
Your only thing we're asking for is an extra 30 days to give her the opportunity to remedy the problem.
I got that. All right, Charlotte County versus Linda Scott Irwin, COD 17-570, pertaining to the parcel of property at 4228 Worcester Drive, Punta Gorda, Florida. I find that the undisputed evidence, including the admissions of counsel, that the violation set forth in the notice of violation are existent on this property. I will accept the county recommendation as my order with the proviso that instead of 30 days, I will give you the 60 days that you've requested.
Thank you, Your Honor.
And that'll be my order.
How long does it normally take for you to issue the order?
Probably just, I've got a proposed one here. I'll just.
Oh, okay. Thank you, Your Honor.
It'll be mailed, Mr. Center.
Thank you.
Oh, just a whole nother one. So let's get this one signed. And you've noted it will send it. Okay, we got that, okay. All right, so. Okay, I think we're back at, there'll be case D as in David. That's okay, I'll work with it. All right, moving on with agenda, Article X of the agenda, case D is in David 17-832, Thelma Nickerson. If you're here on that property, if you'd please approach. Sir, your name, please?
Michael Nickerson.
And my understanding is you're Miss Nickerson's son?
Yes.
Okay. And are you one of the owners of the property, or do you have an interest in it?
I'm just her son. I'm her caregiver. She has Parkinson's.
Okay, thank you, sir. We'll just proceed with the same procedure that we've been doing to this point, and then whatever you have to say, we'll give you a full opportunity, okay? So if you bear with us, and the county's ready to proceed, just give me 1 second to catch up here. Okay.
Officer Nicolosi.
Darcy Nicolosi, Certified Code Enforcement Officer for Charlotte County. The property in violation is 10175 Rafferty Avenue and is zoned RSF 3.5. The owned record is Thelma Nickerson. On March 27, 2017, based upon a complaint, I conducted an inspection of the address and observed the following violation: unsanitary pool. A letter was sent to the owner giving 30 days to comply. A reinspection was conducted of the property, and some new violations were also present. A fence installed without a permit, outside storage of containers, lawnmower, weed eaters, and assorted other debris. During the investigation, I took photographs of the property on May 23, 2017 and July 25, 2017. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit 1.
That concludes our case, Your Honor. Your Honor, just for the record, would the witness state his name and address? Excuse me, Your Honor. Would the witness state his name and address for the record, please?
Sir, your name and address, please.
Michael Nickerson, 10175 Rafferty Avenue, Inglewood, Florida.
Thank you. Sir, do you have any objection to me looking at this?
No.
And those will be admitted as requested and marked accordingly. County's rested, sir. What have you got to tell me?
I've got friends coming over this weekend to finish up everything. I got started on it. I just have more cleaning to do. I've had health issues since November. I had heart failure, so I haven't been able to keep up on things like I should have. But
I'm sure you've got your hands full. You're taking care of your mother.
Yeah.
All right. Let me just pan through the photographs, and I'll be right with you. Anything further, sir?
Nothing.
Anything further from the county?
Like a recommendation, sir? Okay. The county recommends the respondent be found in violation of the cited code sections request that the magistrate enter a 2-year cease and desist order for any future violations, that the respondent be granted 30 days from the date of this order, of the magistrate's order, to clear the zoning violations and to bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $50 per day for each day a violation exists, and that the county be permitted to abate the property in the event of noncompliance, and that the cost of abatement be added to the fines and costs.
Mr. Nickerson, the county's asking that I enter an order given 30 days to clear up the zoning violations, and I know this isn't your property, but is that even feasible, or do you need additional time?
No, I think I can handle that in 30 days.
Okay, thank you. All right, in Charlotte County versus Thelma D. Nickerson, COD 17832, pertaining to the parcel at 10175 Rafferty Avenue, Englewood, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and I'll accept the county recommendation as my order. So, Mr. Nickerson, if this gets all cleared up within 30 days, then that'll be the end of it.
Great.
But the fine kicks in afterward. Okay?
All right, thank you.
Thank you, sir. Have a good day. All right. Looks like N, Hope Daily. All right, agenda item N, COD 17306, Hope Daily, if you're here on that. Okay, thank you. Your name and address, ma'am?
The address that I live in, or the address of the property?
Where do you live?
Okay, Hope Daily, 411 Southeast Street, Jacksonville, Illinois, 62650.
Okay. And you are, this property, are you the owner of that property?
Yes, I am.
Okay, thank you. All right, if the, we're going to proceed with the same procedure, so if the county's ready to proceed, it's first witness, please.
Yes, proceed, Officer John.
Thank you. My name is John Drown, Certified Code Compliance Officer for Charlotte County. 29430 Jones Loop Road is zoned MHC, Manufactured Home Conventional. The owner of record is Hope Daily. This case was initiated by Officer Moore on February 3rd, 2017. When she conducted an inspection finding IPMC violations for exterior structure, including but not limited to protective treatment, roof drainage, windows, door frames, doors, also noted was concrete, metal, and other debris creating junk-like conditions. On March 31st, 2017, a courtesy letter was sent to the homeowner. On May 15th, 2017, a notice of violation was mailed, certified mail, to the owner of record. During the investigation, I took photos on July 17th, 2017, and conducted a follow-up inspection, finding torn or missing screens, boarded up and/or broken windows. These photos accurately represent the conditions I observed. I would like to offer these photographs into evidence as Charlotte County Composite Exhibit 1.
Daly, do you have any objection to me admitting those into evidence?
No, sir.
Okay, so those will be marked and admitted as requested. Please proceed.
Thank you, Your Honor. I have had contact with the property owner. She called and sent an email explaining that there was a recent death and that she made arrangements to have the lawn cut and would begin repairs soon. The notice of violation was served in accordance to Florida Statute 162. This concludes my testimony.
Anything further from the county?
Your Honor, we request that Section 2-5-72 of the notice of violation be dismissed. 2-5-72. That's the first section referenced in the notice of violation.
That'll be dismissed as requested. Ms. Daly?
I spoke to him on the phone a couple weeks ago. I wasn't aware of any of the notices because when I moved up north, I had changed my address, postal service, but I didn't change it, I guess, officially with the, I want to say, property appraiser or website that he gave me. So they were going to a uncle's address, and me and the uncle don't speak, so he was not making me aware of it. And since I was out of state, I clearly didn't see it. And so when he made me aware of it, I immediately called somebody, got the yard taken care of, and my mother passed away July 4th, so I couldn't get down right away. But I've been able to come down here for this, and I'll be back September 9th as well. And I'm going to try to do, I'm here for a couple more days, I'm going to try to fix as much as I can now, and then September I should be down, hopefully with a couple more funds after I get a couple paychecks to fix the rest of the problems.
Sorry to hear about your mother.
Thank you.
Okay, county have a recommendation on this?
Your Honor, the county recommends the respondent be found in violation of the cited code sections, that the request the magistrate enter a 2-year cease and desist order for any future violations, that the respondent be granted 30 days from the date of this order, of your order, to clear zoning violations and bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $50 per day. That's a correction from the agenda, Your Honor. Face a fine of $50 per day for each day a violation exists, and that the county be permitted to abate in the event of noncompliance, and the cost of abatement be added to the fines and costs.
Okay, thank you. In Charlotte County versus Hope Daily, COD 17306 pertaining to the parcel at 29430 Jones Loop Road, Punta Gorda, Florida, I find that the charges set forth in the notice of violation exist on the property. I'm not comfortable that 30 days is going to give you enough time with your mom recently passing, so I'm going to extend that to $60.
Thank you.
I'm sorry,
60 days? Okay,
and
thank
then,
you.
what we'll do is we'll accept a recommendation at a $50 a day fine. In other words, you have 60 days to bring everything into compliance.
Okay.
As long as you do that, then this shouldn't cost
Okay.
anything, okay?
Okay.
That give you enough time?
That should be.
That's about as far out as I feel comfortable going. So.
That's fine. Thank you.
Well, good luck with it then.
Thank you. We're good to go.
R is next one. All right, it'll take us to agenda item R, COD 171024, Denise Stainton. May approach, please. Excuse me, 1 minute.
Okay.
Your name and address, please.
Denise Stainton, 297 Azalea Avenue, Port Charlotte, Florida, 33952.
Okay, thank you. And we'll proceed as we've been doing. So
Okay.
the county's ready to proceed.
Officer Davis.
My name is Paul Davis, Code Enforcement Officer for Charlotte County. The location of the violation is 297 Azalea Avenue, Port Charlotte, zoned RSF 3.5. The owner of record is Denise Ann Staton. On April 7th, 2017, I conducted an inspection of the address and observed the following violations: outside storage of wood, metal, yard waste, and other debris creating junk-like conditions. The rear of the house had new construction on the rear porch, and a search of the Charlotte County database found no permits for the work. I also found violations of international maintenance, property maintenance codes of damage and unprotected fascia, peeling paint, and damaged roof. During the investigation, I took photographs of the property on April 17th, May 30th, June 13th, and July 24th, 2017. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Exhibit Number 1.
Nathan, do you have any objection to me admitting those photographs into evidence?
No, sir.
Okay, thank you. Then those will be marked and admitted as requested.
Thank you, sir.
May proceed.
A warning letter was issued to the homeowner on April 17, 2017. The notice of violation was served in accordance with Florida Statute 162. On July 24, 2017, I conducted the final inspection, and most of the violations are still remaining. She had cleaned up a little bit of the yard waste in the front, but there was still some in the back, but everything else was pretty much from the first time. This concludes my testimony.
Thank you. Anything further from the county at this time?
Nothing further, Your Honor.
Nathan, what's going on?
Okay, my brother said that because I take care of my mom, I go over to her house after work and I make sure she eats and everything, that he was going to go ahead and have my house redone. We waited for FPL. The riser had been from one of the storms. The first of the year, the riser had been bent for the electric, and the electric was pulled out from there. And I waited from the end of February until the end of May before they finally went ahead and installed my electricity from the pole to my house. I applied for a permit and for the riser work to be done. Ken Tyner went out and did the electric work, and we just waited on FPL. I mean, I made almost daily calls to them to see when they were going to be out. It was finally hooked up at the end of May. The guy that my brother was going to have do my fascia work and all, he ended up with some health problems and personal problems, and he couldn't do it. He since has done it. My brother had his son-in-law clear out the whole backyard so FPL could have access to the pole, and he left everything in front of the house. I got people from work, where I work, that came out and put everything to the front, parallel to the street instead of parallel to the driveway, so that the county could come and pick it up, which they did. The dumpster, we waited on them to be emptied. We got another company after that who has been pretty regular about emptying the dumpster. The fascia has been completed. You can see the permit for my windows up. Fascia all around the house has been done. The soffit over under the where the riser is has been replaced. The house we got the paint for the house, and they pressure washed the house. They started painting the house. They have one side of the house painted. The window that was boarded up, got my window permits, that has been replaced. And where they're saying that the enclosure, the porch enclosure, a room, I explained when I had called that they were just supposed to put up plywood because I had everything that was in the house. My brother's having my floors redone. It was put out on my porch, and I didn't want the wind or the rain to damage any of my furniture. Well, the son-in-law that went ahead and cleared out the backyard, went and put tie-vac on. I removed all the tie-vac immediately after I had spoke to the county. But I do have pictures that we've taken since then where everything.
Would you just show me those photographs you'd like to enter into evidence?
Yes, sir.
I won't be able to give them back to you, though. That's why I asked.
Right. And my son only has 2 more windows to put in, and he has the shutters to put up.
While we're doing that, how long do you think it's going to take to get everything up to snuff?
Now that the gentleman with the health problems, he's back, he can work. He said that by the middle of September, it'll all be done.
Okay, thank you.
And they do plan on screening in, taking the wood down and screening in the back porch within a week. And then I can move everything back into the house.
Any objection to the photos?
Your Honor, no objection.
Okay, those would be marked as composite exhibit A for the respondent.
I'm sorry about the quality of my camera. I'm sorry about the quality. My phone doesn't take that great of pictures.
Anything further, ma'am?
I don't believe so.
Anything further from the county?
No, Your Honor, we're prepared for our recommendation.
Hey, please, your recommendation.
The county recommends that the respondent be found in violation of the cited code sections, that the magistrate issue a 2-year cease and desist order against future violations, that the respondent be granted 30 days from the date of your order to clear the violations, the zoning violations, and to obtain all necessary permits and pass all inspections in accordance with the Florida Building Code, and to bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $50 per day for each day a violation exists, and also to permit the county to abate the property in the event of noncompliance, and that the cost of abatement be added to the fines and costs.
Okay, thank you. In Charlotte County versus Denise Ann Staten, COD 171024 pertaining to the parcel at 297 Azalea Avenue, Port Charlotte, Florida. I find that the undisputed evidence establishes the charges set forth in the notice of violation. I'm going to accept in part, the county recommendation. You said you get it all finished probably mid-September. I don't want you to, I don't want to set you up to fail, so I'm going to give you 60 days to do that. You think you can get it done?
Yes, sir. Thank you.
Okay, so that will be my order in the case, okay? And then good luck with that. I mean, you're making a very good effort so far. I just hope everything gets done on time, okay?
Thank you, sir.
You're quite welcome. All right, that takes us to agenda item U, COD 16-1561, Philip Halcomb. I take it you're Mr. Halcomb?
Yes, sir.
And your address, please?
2117 Mississippi Avenue in Inglewood. My first name's Philip.
Okay, thank you, sir. We'll proceed accordingly, so as we've been doing, so just bear with us, okay?
All right.
County ready to proceed?
Officer Bush.
My name is Charlie Bush, Certified Code Enforcement Officer for Charlotte County. 3279 Holcomb Road is zoned RSF 3.5 and owned by Philip Halcomb. On May 17, 2017, I conducted an inspection on the address and observed the following violations: a canopy, a boat, buckets, and other assorted debris on a vacant lot. During the investigation, I took photographs of the property on May 17th and June 5th, 2017. These photos fairly and accurately represent the conditions I observed. I would like to offer these photographs into evidence as County Composite Exhibit 1.
Mr. Halcomb, do you have any objection to me admitting those?
No.
So marked and admitted. Please proceed, Officer Bush.
Several courtesy letters were sent to the owner's addresses. The notice of violation was posted in accordance with Florida Statute 162. On July 31st, 2017, I conducted the final inspection, finding the violations still exist. That concludes my testimony.
Anything further from the county?
Nothing further, Your Honor.
I was out of town for quite a while. I was on vacation. I came back and had a notice of 6 days or 10 days to correct the violations, at which time I was up to appear at a hearing. I appeared at the hearing. I talked to Charlie Bush about this and told him that I would do whatever I could. Ever since then, I have removed a lot of debris. A lot of material has been removed from the building. It doesn't look like it. There was a lot of stuff there. That building has been there for 40 years. I had accumulated stuff in the building for over 20 years. It's taken a heck of a lot to get rid of a bunch of that stuff. I've taken 3 trailer loads of stuff to the dump. I have taken 2 loads, one load to scrapyard, and I took 1 load of motorcycle parts and materials out of there also, okay? And that's only been in the past 30 days. I'm going to need a little more time. I'm asking for 60 days to complete this project. To give you an example, one of the pictures shows that the tree has actually grown over top of the shed. And as a result, I'm going to have to get the chainsaws in there and remove trees as well as trying to get the shed out of there. So, you know, I would appreciate the cooperation for another 60 days, get everything taken care of, and get it out of there, and we'll be done with it.
Anything further, sir?
No, thank you.
County recommendation, please.
Yes, Your Honor. Excuse me. The county recommends the respondent be found in violation of the cited code sections, that the magistrate enter a 2-year cease and desist order for any future zoning violations, that the respondent be granted 15 days from the date of your order to clear the zoning violations, or thereafter face a fine of $50 per day for each day a violation exists, and that your order indicate that the county is permitted to abate the property in the event of noncompliance, and cost of the abatement to be added to the fines and costs.
Thank you. Mr. Halcomb, I think what I'm going to do is I'm going to give you the 60 days that you requested.
Thank you.
But you got to get it finished up in that time. Okay?
Oh, it'll be done.
All right, so in Charlotte County versus Philip D. Halcomb, COD 161561, pertaining to the parcel at 3279 Holcomb Road, Port Charlotte, Florida, I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation. I'll accept the county recommendation as my order with the proviso that we're going to give you the 60 days. And that'll be my order in the case.
Thank you, sir.
Thank you, sir. Have a good day.
You too.
Yeah, and that small smile. Another 30 degrees and I'm going to be still probably into this shit.
That takes care of everybody, right? Yeah, we'll do that. Okay, according to my agenda, it looks like we have everyone present from the respondents covered.
That's our understanding, Your Honor, but maybe you want to make a general...
Anyone else here on a particular case? All right, so what we'll do is, as we traditionally do at the end of the new business, people are present, we'll take a 15-minute recess and reconvene at 11:30.
Visitors and those of us who live in Southwest Florida, especially here in Charlotte County, are fortunate because we have awesome weather all year long. Hi, I'm Todd Dunn from CCTV. There's not a better place to get up, get out, and get active than in one of our many parks. I'm here at Inglewood Beach where they've recently just replaced the playground. Here to tell us more about the playground equipment is Mike Koenig from Community Services. Hey Mike.
Hi Todd.
Tell us about why you guys replaced these.
Well, we have an actual ongoing replacement cycle for all of our playgrounds between 10 and 15 years, which is the actual usual lifespan of a playground.
Now, we're right out here. We're out here in the sun. Come on over in this way. It's pretty bright, and I imagine it gets kind of hot.
Well, it does. You know, the sun beating down on this equipment, especially in the middle of the day like this, makes it pretty warm. So what we're going to be doing is putting a cover over this playground to make it a little more enjoyable for everyone when they're out here.
This is the second one in recent months that you guys have replaced. What other ones, are there other ones, or which ones are in the process of replacing the playground equipment?
Well, the next ones that we have coming in are going to be at Tringali Park in Inglewood and then Deep Creek Park over on Sand Hill Boulevard. We recently replaced South County Regional Park as well as Cedar Point Park.
We're right here at, like I mentioned, at Inglewood Beach where this park playground equipment is located. So you can come out, take advantage of this. The kids get tired of playing in the salt, they can come and play on the playground. If you want a list of other parks that you can get up, get out, and get active at, visit charlottecountyfl.gov. Reporting for CCTV, I'm Todd Dunn.
Say hello to Luke. If you come to one of the many beaches or boat ramps in Charlotte County, you'll be greeted by a new parking meter system. Hi, I'm Elizabeth Billings with CCTV News You Can Use, here with Mike Koenig to tell us more about this new system. Thanks for joining us, Mike.
Glad to be here.
So, what is Luke?
Luke is a new state-of-the-art parking machine system that we have deployed throughout Charlotte County Parks and Recreation facilities.
Tell us about some of the technologies that this new system allows us to use.
Well, this parking machine actually allows us to be in constant communication with the entire system so that we're always able to know how many spaces are available and how many spaces are being used by the public. It also allows us to do some neat things for our customers, such as not requiring you to go back to your space to put a receipt on your dash, or if you need to extend your time, you can do that through your smartphone.
When a customer walks up to the parking meter, what will it ask them?
Well, the first thing it will do is it will ask for your space number. So it's very important when you park in one of the parking lots to make sure you know what your space number is. Once you get to the parking machine, the first thing it will ask you to do is put in the parking space number.
And then you're able to pick if you want just 1 hour, multiple hours. How does that work?
It will ask you if you want to park, pay for just 1 hour, or if you want more than 1 hour. And then you just make that selection that's on the screen and follow the rest of the instructions.
Okay. I see the sign here that it has some telephone capabilities and some smart scan capabilities. Let's talk a little bit about that.
Sure. If you go to your Google Play or iPhone App Store, you can download one of those apps for mobile now and set up an account that allows you to just enter in the parking space number directly into your phone. You don't have to come and use the machine at all. And if your space is about to expire, you'll get a text notification letting you know that it's time to add additional funds.
Can a citizen get a yearly parking pass?
Yes, they can. They can go on the website and download an application and mail it to us, or simply call us at 625-7529, and we'll be glad to help them get an annual parking pass. They can also get seasonal parking passes for 3 months or 6 months.
Great, thank you. Thanks for joining us.
Thank you.
So, remember, when you say hello to Luke, the first thing he's going to ask you for is your parking space number. I'm Elizabeth Billings reporting for CCTV, News You Can Use. actual fire starts every 11 minutes and 19 seconds. Hi, I'm Elizabeth Billings with CCTV News You Can Use, and 67% of those start in the kitchen. I'm here with Dee Hawkins from Charlotte County Fire EMS to tell us more about fire extinguisher safety and some of the statistics. Thanks for joining us, Dee.
Thank you for having me.
So, tell us a little bit about the statistics.
Well, we know that out of the many fires that we respond to, 68% of those fires are residential home fires. And so it's so important for residents to be prepared and know how to use a fire extinguisher, because maybe we can prevent some of those fires.
How many people are injured from house fires?
Well, we know in residential structure fires, with our latest statistics from the State Fire Marshal in 2015, over 1,113 people were injured in residential home fires.
And what's the best way to prevent that?
The best way to prevent it is to be prepared. So having things like exit plans to exit structures when they're on fire, but more so putting out the fire before it consumes the structure. And knowing how to use a fire extinguisher is so important. Every home should have one.
Where can you get a fire extinguisher?
Residents can purchase fire extinguishers in their local big box store, whether it's a local hardware store or a department store. There's a lot to choose from, but it's easy to decide which fire extinguisher to pick.
All right, thank you. We're going to go talk to the Charlotte County Fire Marshal about what type of fire extinguisher you need. Hi, Scott Morris. Thanks for joining us. Tell us what you do.
I am the Fire Marshal for Charlotte County, and I'm in charge of the Fire Prevention Division with the county. We are in charge of all new construction with the county and existing occupancies and training with the public, with Dee Hawkins, our PIO.
Now, if I was going to go out and buy a fire extinguisher, where would I start?
You can go to any box store. Most of them have fire extinguishers for residents, not for commercial. They are for the residential use only. If you're buying for a commercial, you need to buy that from a licensed company through the state of Florida that can service and tag the fire extinguisher.
Now, is there different types of fire extinguishers?
There's a lot of different types of fire extinguishers. The most common for a resident would be a 10-pound, and it's an ABC fire extinguisher.
What does ABC stand for?
ABC will take care of anything that leaves an ash, electrical, flammable liquids, stuff like that. So that encompasses everything. You can get also the single type where it's just an A or just a B or a C, but for residential, the most common, they'll just get an ABC that takes care of everything.
How many fire extinguishers should someone have in their house?
The code requires about a 75-foot travel distance. For a normal-sized home, if you had one in your kitchen, maybe one in your garage, if you have a separate laundry room, somewhere of your high hazard areas that you would want to have one, so to where you don't have to travel too far to get one.
Are they easy to use, or do you need special training?
We provide training here. They're not that difficult to use. However, depending on the age, the size of the person, there are certain limitations like that because of how the fire extinguisher works. But overall use, we do provide that training.
There's a fire in my house. What is the first thing I do?
You need to call 911. You need to get responding units to come to your address in case the fire is to overcome what your capabilities are. Always remember two things. You never put the fire between you and an exit. You always want to have an exit to get out of your house in case need be. And you want to make sure everybody's out of the house.
Now, let's show us how to use this fire extinguisher.
It's real simple to remember how to use a fire extinguisher. 4 little letters, one word, PASS, P-A-S-S. And to start with the first letter, P, you want to pull your pin. Every fire extinguisher will have a pin, just like this one. And the reason for that pin is I can hold it all day long like this and it doesn't set off the fire extinguisher. Once I pull the pin out, it's a live fire extinguisher. So once you do, you pull your pin, who cares where it goes, just drop it. Second letter, A, pull your pin and pull the nozzle, and then you want to aim. You always want to aim at the base of the fire, never above it, always at the base, because what you're trying to do is suffocate the fire, try to put the fire out that way. If you shoot above the fire, all the agent that's in the fire extinguisher will not get to the base of the fire to put the fire out. The first S in PASS is you want to squeeze your handle. Once you squeeze your handle, now the S, and all this comes really quick, you want to sweep. You want to sweep your nozzle at the base of the fire. And at that point, you want to start at least about 6 feet away from the fire, working your way into it, and constantly sweeping. This is an easy fire extinguisher to use. Even you can try this, and we can knock it out.
Remember pass, pull, aim, squeeze, and sweep. That was easy. What a great piece of training equipment. How has that changed the way that you're able to train?
Well, first of all, we were very lucky to receive this equipment with grant monies. Also, with this piece of equipment, we were able to not have to worry about doing this outside. We are able to not have our crews on standby for an outside burn. And with the weather, sometimes we were able to bring people in here now and do this training inside our classroom, where before we would have to find a place to do it outside.
You do training for residents as well?
Yes. If they contact our office, we can provide that training.
Thank you, Scott. That was great information.
Thank you.
It is important for everybody to have a fire extinguisher in their home. And remember, it's easy. Pull, aim, squeeze, sweep. If you or an organization are interested in fire extinguisher safety, you can contact Charlotte County Fire EMS at 941-833-5600. I'm Elizabeth Billings reporting for CCTV, News You Can Use.
Thank you. We're back in session. At this time, we'll call, let's see.
I believe we're on item B, Your Honor.
Agenda item B is in boy, COD 171675, Roberto Romero. If you're here in that case, please approach the podium. I note that no one is present on behalf of the respondent and that we have Officer Leonard ready to proceed, so if you would.
Officer Leonard.
My name is Rhonda Leonard. I'm a certified code enforcement officer for Charlotte County. 22187 Belinda Avenue is zoned RSF 3.5. The owner of record is Roberto Romero. On June 8th, I conducted an inspection at the address and noted the following violation of outside storage of miscellaneous items, including but not limited to furniture, shelving, boxes, items under a tarp, and assorted other debris. During the investigation, I took photographs of the property on June 28th and July 27th. These photos fairly and accurately represent the conditions I observed. I'd like to offer these photographs into evidence as County Composite Exhibit 1.
Those are marked and admitted as requested. Please proceed.
A courtesy letter was sent to the owner giving 10 days to comply with the listed violations. I've had no contact with the owner or the tenant. The notice of violation, notice of hearing was served in accordance with Chapter 162 of the Florida statutes. I conducted the final inspection on July 27th, finding the outside storage remains. This concludes my testimony.
Thank you. If the county has nothing further, its recommendation, please.
Yes, Your Honor. The county recommends the respondents be found in violation of the cited code sections listed in the notice of violation, that the magistrate enter a 2-year cease and desist order for future violations, that the property owner be granted 15 days, 15 days from the date of your order to clear the zoning violations, or thereafter face a fine of $50 per day for each day a violation exists, and that the county be permitted to abate the property in the event of noncompliance, and that the cost of abatement be added to any other fines and costs.
Okay, thank you. By the way, Ms. Patel used to be able to get that through all of that in about half the time.
She's much smarter than I am.
Me too. Charlotte County versus Roberto Ribeiro, COD 171675, pertaining to the parcel at 22187 Belinda Avenue, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and accept the county's recommendation as my order.
You love me.
Photographs right there.
It was a change.
On, okay. So we'll just go ahead and throw that one out then. What did we change on that?
50.
Oh, 50. No. Yeah. Okay.
It takes a long time to load up.
So that takes us to... All right, we'll move on to Agenda E, COD 171435, Stephen Roche. If you're here on that matter, please approach the podium. I note that no one is present on behalf of the respondent. So we have Officer Nicolosi. If you're ready to proceed, please.
Officer Nicolosi.
Darcy Nicolosi, Certified Code Enforcement Officer for Charlotte County. The property in violation is 5045 North Beach Road and is zoned MMF 10. The owner of record is Stephen Roche. On May 15, 2017, based upon a complaint, I conducted an inspection of the address and observed the following violations: unlicensed trailer full of debris parked in yard, outside storage of appliances, wood, ladders, containers, power washer, crab traps, and soda debris. A letter was sent to the owner, giving 10 days to comply. During the investigation, I took photographs of the property on May 15th, 2017, May 30th, and July 25th. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit 1.
Those will be marked admitted as requested. Please proceed.
The notice of violation was served in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance, reference to the existing violations. On July 25th, 2017, I conducted the final inspection, finding all violations remained on site. This concludes my testimony.
Okay. The county has nothing further. Its recommendation, please.
County recommends the respondents be found in violation of the cited code sections listed in the notice of violation, that the magistrate enter a 2-year cease and desist order against future violations, that the property owner be granted 15 days from the date of your order to clear the zoning violations, or thereafter face a fine of $100 per day for each day a violation exists, that the county be permitted to abate the property in the event of noncompliance, and the cost of abatement to be added to the fines and costs.
Okay, thank you. Charlotte County versus Stephen Roche, COD 171435, pertaining to the parcel at 5045 North Beach Road, Englewood, Florida. I find that the undisputed evidence establishes the charges set forth in the notice of violation, and accept the county recommendation as my order. This is Steve Roche. Is he on another one?
Mm-hmm.
Okay. Okay, moving to agenda item F, Coco Kai and Stephen Roche.
Officer Nicolosi.
Matter, please approach. No one is present on behalf of the respondents, and I see we have Officer Nicolosi again, so if you're ready to proceed, please do so.
Darcy Nicolosi, Certified Code Enforcement Officer for Charlotte County. The property in violation is located at 5040 North Beach Road and is zoned MMF10. The owner of record is Steve Roche. On May 15, 2017, I conducted an inspection finding an addition added to Unit 7 without a permit being issued. Outside storage of wood, tarps, tires, AC units, screens, PVC pipe, lawnmowers, and assorted other debris. This case is being brought straight to the special magistrate, as there are several other cases on this property. During the investigation, I took photographs of the property on May 15, 2017, July 6, July 27th. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit 1.
Those are marked and admitted as requested. Please proceed.
The notice of violation was served in accordance with Florida Statute 162 by posting on July 6, 2017. The respondent was given 10 days to come into compliance, reference the existing violations. On July 27th, I conducted the final inspection, finding conditions remained the same. A review of the database found the permit had not been submitted for the work done on the property. This concludes my testimony.
Thank you. If the county has nothing further, its recommendation, please.
Officer Nicolosi, do those photographs accurately represent the status of the property when you did your inspection? Say again.
For this case, yes.
Your Honor, this is a very significant case, so the recommendation is going to be a little bit something we haven't heard before. No, I have not given to you before. In this case, the county recommends respondents be found in violation of the code sections listed in the notice of violation, that the special magistrate enter a 5-year cease and desist order for any future violations, that the respondent be granted 30 days from the date of your order to clear the zoning violations, that this respondent apply for and obtain all necessary permits to bring the property into compliance, and then pass all inspections in accordance with the Florida Building Code, or obtain a demolition permit to restore the property to its original condition, or thereafter face a fine of $100 per day for each day the violation exists. We also request that the county be permitted to abate the property in the event of noncompliance, and the cost of abatement be added to the fines and costs.
Thank you. I have no problem with the recommendation. So in Charlotte County versus COPWATCH and Stephen Roche, COD 171479, also applying to 5040 North Beach Road, and also to the same address, Unit 7 in Englewood, Florida. I find that the undisputed evidence establishes the charges set forth in the notice of violation, and accept the county's recommendation as my order. I think I put the, oh, you got it. Okay. All right, next agenda item is COD 171592, Robert Stavala. That is item G on the agenda. If you're present on that case, please approach the podium. I note that no one is present on behalf of the respondent. Officer Nicolosi's teed up, so go ahead.
Officer Nicolosi.
Darcy Nicolosi, Certified Code Enforcement Officer for Charlotte County. The property in violation is 6188 Rosewood Drive and is zoned RSF 3.5. The owners of record are Robert and Pascal Stavilla. On June 1st, 2017, based upon a complaint, I conducted an inspection of the address and observed the following violation: outside storage of wood, ladders, appliances, fencing, pile of trash bags, PVC pipe, wheelbarrow, recycle bins, 5-gallon buckets, tires, and a sort of other debris. This is the second case for the same violations. The first case was submitted before the hearing. During the investigation, I took photographs of the property on June 1st and July 25th, 2017. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit 1.
All right, those will be so marked and admitted as requested. Please proceed.
The notice of violation was served in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance, reference the existing violations. On July 25th, I conducted the final inspection, finding outside storage remained on site. This concludes my testimony.
Thank you. If the county has nothing further, its recommendation, please.
County recommends the response be found in violation of the cited code sections, that the special magistrate enter a 2-year cease and desist order against future zoning violations, that the response be granted 15 days from the date of your order to clear the zoning violations or thereafter face a fine of $100 per day for each day a violation exists, that the county be permitted to abate the property in the event of noncompliance and cost of the abatement to be added to the fines and costs.
Thank you. In Charlotte County versus Robert and Pascal Stavella, COD 17-1592, pertaining to parcel at 6188 Rosewood Drive, Inglewood, Florida. I find that the undisputed evidence establishes the charges set forth in the notice of violation and accept the county recommendation as my order in the file. That will take us to agenda item H, COD 152623 PL Conan. If you're here on that matter, please approach the podium. I note that no one is present on behalf of the respondent, so we have Officer Moore. If you're ready to proceed, please.
Moore.
Renell Moore, Certified Code Enforcement Officer for Charlotte County. 4414 Wincoop Circle is zoned RSF 3.5. The owner of record is PL Cone. On May 30th, 2017, I conducted an inspection of the property and observed the following violations of finding I have a typographical error here, of having windows installed with that have an expired permit, and also a stucco peeling from the side of the house. During the investigation, I took photographs of the property on April 17th, 2017, May 30th, 2017, and July 25th, 2017. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit 1.
Those will be marked and admitted as requested. Please proceed.
A courtesy letter was sent to the owner's address outlining the violations and allowing 30 days for compliance. I've had no contact with the owner. The notice of violation was served in accordance with Florida Statute 162. On July 25th, 2017, I conducted the final inspection, finding that the violations still exist. This concludes my testimony.
Thank you. If the county has nothing further, its recommendation, please.
The county recommends respondent be found in violation of the code sections listed in the notice of violation, that the respondent be granted 30 days from the date of your order to renew the expired permit, and pass all inspections in accordance with the Florida Building Code, and bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $100 per day for each day a violation exists.
Thank you. In Charlotte County versus P.L. Conan, COD 152623, pertaining to the parcel of 4414 Wincoop Circle, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and accept the county recommendation as my order. That takes us to agenda item I, COD 171043, Dimitri Pierre Louis and Maud Pierre Louis. You're here in that case, please approach podium. I note that no one is present on behalf of the respondent, so we have Officer Moore. If you'd proceed, please.
Renell Moore, Certified Code Enforcement Officer for Charlotte County. 18298 Caddy Avenue is zoned RSF 3.5. The owner of record is Dimitri and Maud Pierre Louis. On May 22, 2017, I conducted an inspection of the property and observed the following violations of a shed that was installed without a permit. During the investigation, I took photographs of the property on April 17th, May 22nd, 2017, and July 25th, 2017. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs and evidence as County Composite Exhibit 1.
Those have been marked and admitted as requested. Please proceed.
A courtesy letter was sent to the owner's address outlining the violations and allowing 30 days for compliance. I have had no contact with the owner. The notice of violation was served in accordance with Florida Statute 162. On July 25, 2017, I conducted the final inspection, finding that the violations still exist. This concludes my testimony.
Thank you. If the county has nothing further, its recommendation, please.
Yes, Your Honor. The county recommends the respondents be found in violation of the code sections listed in the notice of violation, that respondents be granted 30 days from the date of this order to apply for and obtain all necessary permits to bring the property into compliance, and then pass all inspections in accordance with the Florida Building Code, or thereafter face a fine of $50 per day for each day a violation exists.
Thank you. In Charlotte County versus Demetri and Maud Pierre-Louis, COD 17-1043, pertaining to the parcel at 18298 Caddy Avenue, Port Charlotte, Florida, I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and accept the county recommendation as my order. Takes us to agenda item J, COD 17-1304, Gennady Gigrovich. If you're present on that matter, please approach the podium. I note that no one is present on behalf of the respondent. I also note that county wishes to dismiss the violation in 303.1.
That's correct, Your Honor.
Okay, that'll stand dismissed, and I see we have Officer Moore. So if you are ready to proceed, please do so.
Brunell Moore, Certified Code Enforcement Officer for Charlotte County. 4523 Collingswood Boulevard is zoned RSF 3.5. The owner of record is Gennady and I. Grigorovich. On June 8, 2017, I conducted an inspection of the property and observed the following violations of a concrete fire pit, a picket fence in disrepair, a roll-down screen on the garage that is in disrepair, and other miscellaneous items creating junk-like conditions and prohibited use of the property. Torn lanai screens, a damaged screen on a back window, and a dock with rotting wood and is in disrepair. During the investigation, I took photographs of the property on May 3, 2017, June 8, 2017, and July 25, 2017. These photos fairly and accurately represent the conditions I observed. I'd like to offer the photographs into evidence as County Composite Exhibit 1.
Those will be marked and admitted as requested.
A courtesy letter was sent to the owner's address outlining the violations and allowing 30 days for compliance. I've had no contact with the owner. The notice of violation was served in accordance with Florida Statute 162. On July 25, 2017, I conducted the final inspection, finding that the violations still exist. This concludes my testimony.
Thank you. If the county has nothing further, its recommendation, please.
Yes, Your Honor. The county recommends the respondent be found in violation of the cited code sections except for 303.1, which has been dismissed, that the county magistrate enter a 2-year cease and desist order for any future violations, that the respondents be granted 30 days from the date of your order to clear the zoning violations and bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $50 per day for each day a violation exists, that the county be permitted to abate the property in the event of noncompliance and the cost of the abatement to be added to the fines and costs.
All right, thank you. In Charlotte County versus Gennady Gigrovich, 17-1304 COD, pertaining to the parcel at 4523 Collingswood Boulevard, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and accept the county recommendation as my order. We should save that. Everybody wonders what we're packing up over here. Okay, that takes us to agenda item K. Gary and Judith Alexander. If you're here on that matter, please approach the podium. I note that no one is present on behalf of the respondent. County's ready to proceed. I see we have Officer Moore lined up. So
Moore.
Brunell Moore, Certified Code Enforcement Officer for Charlotte County. 18321 Wolbert Circle is zoned RSF 3.5. The owner of record is Gary K. and Judith A. Alexander. On June 28th, I conducted an inspection of the property and observed the following violations of miscellaneous items, including but not limited to multiple inoperable unregistered vehicles, an inoperable unregistered boat and trailer, an inoperable van full of junk and other miscellaneous items creating a junk-like condition, and a pool that is not properly being maintained. During the investigation, I took photographs of the property on March 6, 2017, May 16, 2017, May 30, 2017, June 28, 2017, and July 25, 2017. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs and evidence as County Composite Exhibit 1.
Those are have been marked and admitted into evidence as requested. Please proceed.
A courtesy letter was sent to the owners giving owner's address outlining the violations and allowing 10 days for compliance. I have had no contact with the owner. The notice of violation was served in accordance with Florida Statute 162. On July 25, 2017, I conducted the final inspection finding that the violations still exist. This concludes my testimony.
Thank you. If the county has nothing further, its recommendation, please.
Your Honor, the county recommends the respondents be found in violation of the cited code sections, that the special magistrate enter a 5-year cease and desist order for future violations, that the respondents be granted 30 days from the date of this order to clear the zoning violations and bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $100 per day for each day a violation exists, and that the county be permitted to abate the property in the event of noncompliance and cost of the abatement to be added to the fines and costs.
Thank you. In Charlotte County versus Gary and Judith Alexander, COD 17-1553, pertaining to the parcel at 18321 Wolbert Circle, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and accept the county recommendation as my order. Agenda item L, COD 1763, Kevin Cupper. If you're present on that matter, please approach the podium. I note that no one is present on behalf of the respondent. It looks like we have Officer Roadhurst ready to go, so
Officer Roadhurst.
Good morning. My name is Gary Roadhurst, Certified Code Compliance Officer for Charlotte County. The location of the violation is 1067 Riggs Street, zoned RSF 3.5. The owner of record is Kevin Cupper. On January 9th, 2017, I conducted an inspection of the property, finding a screen enclosure had been installed around the lanai without the required permit. I took photographs of the property on January 9th, April 6th, and July 27th of 2017. These photos fairly and accurately reflect the conditions I observed. I'd like to offer the photographs into evidence as County Composite Exhibit Number 1.
Okay, those are marked and admitted as requested. Please proceed.
The notice of violation was sent in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance, reference the existing violations. I have had numerous conversations with Wayne Habercorn, who actually has been added to the deed since this case has been put together. He's trying to get the engineering specifications for the permit, but has so far been unable to do it. In fact, this case was continued since June in order to give them the opportunity to do it. On July 27th, I conducted a final inspection, finding the enclosure is still in place, and there's still no permit or application for a permit on file. I did receive a call from Wayne yesterday to let me know the contractor is putting together the information for the permit. But they'll be out of town until August 9th, and he'll take care of the permit as soon as he gets the information. That concludes my testimony.
I noticed in your report that Wayne Habercorn isn't listed as an owner. Is that accurate?
It is accurate now. The information just recently got updated, and so that's why it was not included with the original NOV and so forth. That information just became available.
Okay, thank you. That's what I wanted to find out. All right, the county has nothing further. Its recommendation, please.
Your Honor, the county recommends the respondents be found in violation of the code sections listed in notice of violation, that the respondents be granted 30 days from the date of this order to apply for and obtain all necessary permits to bring the property into compliance, and then pass all inspections in accordance with the Florida Building Code, or obtain demolition permit to remove all improvements, or thereafter face a fine of $50 per day for each day a violation exists.
Thank you. Charlotte County versus Kevin Cupper, COD 1763, pertaining to the property located at 1067 Riggs Street, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and accept the county's recommendation as my order. That brings us to agenda item M, COD 163857, NYMT Loan Financing Trust. If you're present on that matter, please approach the podium. I noted no one is present on behalf of the respondent. We have Officer Drown teed up, so please proceed.
Officer Drown.
Thank you. My name is John Drown, Certified Code Compliance Officer for Charlotte County. 5605 Fairway Drive is zone RSF 3.5, residential single family. The owner of record is NYMT Loan Financing Trust. This case was initiated by Officer Moore on December 19, 2016, when she conducted an inspection finding IPMC violations for the exterior structure, including but not limited to protective treatment, roof and drainage, windows, doors, frames, door frames and doors. On May 15, 2017, a notice of violation was mailed, certified mail, to the owner of record. On July 18, 2017, I conducted a follow-up inspection finding rotted areas of the exterior structure and siding, in addition to screens rotted, rotted wood on the roof fascia, soffit. I took photos. I did not find any permits issued for repairs. These photos accurately represent the conditions I observed. I would like to offer these photographs into evidence, Charlotte County Composite Exhibit Number 1.
Those will be marked and admitted as requested. Please proceed.
Thank you, Your Honor. I have not had any contact with the property owners. The notice of violation was served in accordance to Florida Statute 162. This concludes my testimony.
Thank you. If the county has nothing further, its recommendation.
Yes, Your Honor, the county recommends the respondent be found in violation of the code sections listed in the notice of violation, that the respondents be granted 30 days from the date of this order, of your order, to bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $100 per day for each day a violation exists.
Thank you. In Charlotte County versus NYMT Loan Financing Trust, COD 163857, pertaining to the parcel at 5605 South Fairway Drive, Punta Gorda, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation, and accept the county's recommendation as my order. That takes us to agenda item P as in Paul, COD 171487, Boyce Maxwell. If you're present on that matter, please approach the podium. I note that no one is present on behalf of the respondent. If the county is ready to proceed with Officer Drown's testimony, please do so.
Officer Drown.
Thank you. My name is John Drown, Certified Code Compliance Officer for Charlotte County. 6150 Golf Course Boulevard is zone RSF 3.5, residential single family. The owner of record is Boyce J. Maxwell. This case was initiated by Officer Williamson on May 22, 2017. Officer Williamson conducted a site inspection finding grass was exceeding 12 inches in height. On June 5, 2017, an amended notice of violation was mailed to the homeowner. On June 8th, June 30th, and July 31st of 2017, I went to the address and took photos. These photos fairly and accurately represent the conditions I observed. I would like to offer these photographs into evidence as Charlotte County Composite Exhibit Number 1.
All right, those will be marked and admitted as requested.
Thank you, Your Honor. I have not had any contact with the property owner. The notice of violation was served in accordance to Florida Statute 162. This concludes my testimony.
Okay, thank you. If the county has nothing further, its recommendation, please.
Your Honor, the county recommends the respondent be found in violation of the cited code sections, that the special magistrate enter a 2-year cease and desist order for any future zoning violations, that the respondent be granted 15 days from the date of your order to clear the zoning violations or thereafter face a fine of $50 per day for each day a violation exists, that the county be permitted to abate the property in event of noncompliance and the cost of the abatement to be added to the fines and costs.
Thank you. Charlotte County versus Boyce J. Maxwell, COD 17-1487, pertaining to the property at 6150 Golf Course Boulevard, Punta Gorda, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and accept the county's recommendation as my order. Agenda item Q, COD 16-3238, Joseph and Diana Wolf. If you're present on that matter, please approach the podium. I note that no one is present on behalf of the respondent, so if the county is ready to proceed with Officer Davis.
My name is Paul Davis, Code Enforcement Officer for Charlotte County. The location of the violation is 4363 Jackson Street, Port Charlotte, Zone CR 3.5. The owner of record is Joseph S. and Janina Wolf. Better? On May 8, 2017, I conducted an inspection of the address and observed the following violations. An inoperable RV in the driveway created prohibited use of the property and junk-like conditions. I also have an expired permit for electric and shed and hot tub that expired on April 29th, 2017. During the investigation, I took photographs of the property on May 8th, June 25th, June 23rd, and July 25th, 2017. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit Number 1.
Those will be marked and admitted as requested. Please proceed.
A letter was sent to the homeowner on May 9th, 2017, explaining his problems. Never had any other contact with him after that. The notice of violation was served in accordance with Florida Statute 162. On July 25th, 2017, I conducted the final inspection, finding the violations remained the same. This concludes my testimony.
Thank you. If the county has nothing further, its recommendation.
Your Honor, the county recommends respondents be found in violation of the code sections listed in the notice of violation, that the magistrate enter a 2-year cease and desist order for any future violations, that the respondents be granted 30 days to clear the zoning violations and to renew the expired permits and pass all inspections in accordance with the Florida Building Code, or thereafter face a fine of $50 per day for each day a violation exists, that the county be permitted to abate the property in an event of noncompliance, and cost of abatement to be added to the fines and costs.
Thank you. In Charlotte County versus Joseph and Janina Wolf, COD 16-3238, pertaining to the parcel at 4363 Jackson Street, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and accept the county recommendation as the order in that matter. Takes us to agenda item S, COD 17-1150, Christopher McLeod. If you're present on that matter, please approach the podium. I note that no one is present. I also note that the county wishes to dismiss Section 3-9-5B and FPC Section 101.5. Is that correct?
It's actually Section 105.1, Your Honor, but yes, that is correct.
Thanks. Those will stand dismissed then. If the county is ready to proceed, its first witness.
Yes, Officer. Officer Davis.
My name is Paul Davis, Code Enforcement Officer for Charlotte County. The location of the violation is 3324 Elkham Boulevard, Port Charlotte, zoned RSF 3.5. The owner of record is Christopher Scott McLeod. On April 20th, 2017, I conducted an inspection of the address and observed the following violations at a boat trailer with triaxles in a residential area in violation of Charlotte County Code. During the investigation, I took photographs of the property on April 20th, May 11th, June 2nd, June 20th, and July 25th, 2017. These photos fairly and accurately represent the condition I observed. I would like to offer their photographs into evidence as County Composite Exhibit Number 1.
Thank you. Those will be marked and admitted. Please proceed.
A letter was sent to the homeowner on May 12, 2017. I received one phone call, but nothing was ever taken care of. The notice of violation was served in accordance with Florida Statute 162, and on July 25, 2017, I conducted the final inspection, finding the violations still remain the same.
Thank you, sir. If the county has nothing further, its recommendation, please.
Yes, Your Honor. The county recommends the respondent be found in violation of the cited code section, that the special magistrate enter a 2-year cease and desist order against any future violations, that the respondent be granted 15 days from the date of your order to clear the zoning violations, or thereafter face a fine of $50 per day for each day a violation exists, that the county be permitted to abate the property in the event of noncompliance, and the cost of the abatement to be added to the fines and costs.
Thank you. In Charlotte County versus Christopher Scott McLeod, COD 171150, pertaining to the parcel at 3324 Elkham Boulevard, Port Charlotte, Florida, I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and accept the county recommendation as my order.
See what you started.
You want to take it? You want to take? I think there's some more in that little cabinet right there behind you. You want to go ahead, don't you? Yeah. Okay. We seem not to be able to keep our coffee in our cups up here.
Oh my.
But okay, that takes us to agenda item T's and Tango. COD 171495, Joseph and Mary Klobuchar. If you're present on that case, please approach the podium. Note that no one is present on behalf of the respondents. So if Officer Davis is ready, please proceed.
Officer Davis.
My name is Paul Davis, Code Enforcement Officer for Charlotte County. The location of violation is 3263 Brooklyn Avenue, Port Charlotte, zoned RSF 3.5. The owner of record is Joseph Klobuchar. On May 8, 2017, I conducted an inspection of the address and observed the following violations: an inoperable vehicle in the driveway, plastic tubs, assorted miscellaneous items creating junk-like conditions, and prohibited use, and also an in-ground pool that was in disrepair. The water was green and it wasn't working. During the investigation, I took photographs of the property on May 23rd, July 24th, 2017. These fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit Number 1.
Those be marked and admitted as requested. Please proceed.
Code compliance request was issued to the homeowner on May 23rd, 2017. Notice of violation was served in accordance with Florida Statute 162. On July 24th, 2017, I conducted the final inspection, finding that the violations remain the same.
Thank you. If the county has nothing further, its recommendation.
Your Honor, the county recommends the respondents be found in violation of the cited code sections, that the special magistrate enter a 2-year cease and desist order for any future violations, that the respondents be granted 30 days from the date of your order to clear the zoning violations and bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $50 per day for each day a violation exists, that the county be permitted to abate the property in the event of noncompliance, and the cost of the abatement to be added to the fines and costs.
Thank you. Charlotte County versus Joseph and Mary Lou Klobuchar, COD 171495, pertaining to the parcel at 3263 Brooklyn Avenue, Port Charlotte, Florida. I find that the undisputed evidence establishes the existence of the charges set forth in the notice of violation and accept the county's recommendation as my order. Takes us to case V. Victor on the agenda. COD 171016 CS Parasidio Holding, LLC. If you're present on that case, please approach the podium. I note that no one is present on behalf of the respondent, so we have Officer Bush, if you're ready to proceed.
Yeah. My name is Charlie Bush, Certified Code Enforcement Officer for Charlotte County. 17104 Ursula Avenue is zoned RSF 3.5. The owner of record is CS Paradisco Holding, LLC. On May 25th, 2017, I conducted an inspection of the address and observed the following violations. A boat on blocks stored on a vacant lot. During the investigations, I took photographs of the property on April 11th, May 3rd, and May 25th. These photographs fairly and accurately represent the conditions I observed. I would like to offer these photographs into evidence as County Composite Exhibit 1.
It goes to be marked and admitted. I guess I mispronounced the name of the respondent.
So did he.
You don't get to say disco too often. But courtesy letter was sent to the owner's address. Notice of violation was served in accordance with Florida Statute 162, and on July 31st, I conducted the final inspection, finding the violation still remains. That concludes my testimony.
Thank you. If the county has nothing further, its recommendation.
County recommends the respondent be found in violation of the cited code sections, that the special magistrate enter an order, a 2-year cease and desist order for future violations of the zoning code, that the respondent be granted 15 days from the date of your order to clear the zoning violations or thereafter face a fine of $100 per day for each day a violation exists, that the county be permitted to abate the property in the event of noncompliance and cost of the abatement be added to the fines and costs.
Okay, thank you. In Charlotte County versus CS Paradiso, I guess it is, Holding, LLC, case 17-1016, relating to 17104 Ursula Avenue, Port Charlotte, Florida. I find that the undisputed evidence establishes the charges set forth in the notice of violation and accept the county recommendation as my order. And according to my agenda, that takes care of all of the new business cases.
We agree, Your Honor.
Okay, thanks. Takes us to staff.
Officer Bush would like to hang around a little longer, though, he told me.
Okay. Takes us to agenda item 11, staff and citizen input. Nobody wants to tell me what a wonderful job I'm doing? Okay.
You're doing a fine job.
You are. You're doing wonderful.
We'll stand adjourned.
Hey, Charlotte County. This is Charlotte County COPWATCH, and I found that I had to make a change this ending on my videos, letting you know about the channel and fair use laws, you know, how we can report on other people's reporting and how it's good, how it's bad, etc. But you guys can look it up yourself. It is legal. It's in there. But like I've told you before, that I've been cut off from making money on YouTube for 4 years. It's really weird, bizarre, but they cut the money off, but they said you can keep the channel, and now YouTube makes all the money. And if you get bored, plug it into Social Blade website, and you'll see that they are making a huge amount off the site. Right now it's at 63 million views, 53,000 subscribers, almost 3 million views a month. You know, trying to wake people up, and I make nothing. In fact, I got a customer that's ex-congressman. He said if I could ever find a lawyer, sue YouTube on it. But because this is nuts, 4 hours a day, and to save America. You know, but at the same time, it's worth it. Look at what our founding fathers did. They died for this country. So, but getting back to the money part, this is why I'm redoing the video. Is my dream of everyone giving $1, and it's going to be $53,000 a year, or if they did Patreon, which you know, can be monthly. That is not working. That'd be great if it did. Nothing is perfect. And I appreciate the people that do donate, you know, what they can on PayPal. And there again, I'm letting you guys know that is not much. Is, you know, monthly is, oh my god. So anyways, yes, you cannot live on it. It's very, very, very low amount. But the dollar things, I do appreciate that. But when I first said everybody give $1, that's not working. I'm just I'm just letting you guys know it's, yeah, that's that dream. Everybody gives $1. 53,000 subscribers, it's not working. So yes, if you can give more than that, you know, I appreciate it. Like I said, you know, I'm in a unique situation where, you know, we're already debt free, and I'm not rich, but with the little business that we have, I am able to do what I am able to do 45 hours a day, you know, letting you guys know what's going on. In 4 years, I've did the whole thing myself, 12,000 videos on there. I literally get emails where people are like, holy crap, I never knew it was this bad. And it is this bad, and it's getting worse every day because we have the internet, we have cell phones, we have cameras everywhere now, and it's just disgusting what's going on. And then, as you guys know, too, now we got Trump, we got Jeff Sessions doing a war on drugs, and now he wants to go after the forfeiture laws again. It's just unfreaking real. So, if you can give more than that, that dream of everybody giving $1, yeah, that old video, that's not working. They're not, they're just not. So anyways, if you can give more than that, that dream is not working. Hardly anybody is giving. There you go. So that's why I'm remaking the video. If you can give more than that, that would be great. And there again, like I said, the Patreon's there. There is some people on there that are starting to give, but there again, it's very, very low. And like I said, I don't want to get rich off of that. I'm going to keep doing what I'm doing because, you know, it's still so stinking corrupt. It's not even funny. My court case that I'm going to be paying out of my pocket myself with Charlotte County's coming up. They illegally looked me up and then posted all my information on LEOAFFAIRS website. They basically doxed me, however you want to say that. I forget what the word is, and they outed me, man. And that information on that site went out to 500 sheriffs, deputies, people that work at the jail, etc., etc., etc. So, yeah, it is very, very scary, but we're going to do a federal case, 1983 case, violating freedom of speech. We have 17 cameras in the house now. We got 2 cameras in the car. I always carry a camera plus a cell phone. A lot of people are highly recommending I get a vest now. If I could, if the wife would let me, I would run for sheriff. We are trying to push the thing nationwide right now. Where just to mix it up and to get the topics out there is register to run for sheriff, NPA, no party affiliation, as a write-in, and that is completely free, and you can participate in the elections. And there's a lot of stuff. We got a guy, James McLinnis in Pinellas County, Tampa, who almost won. He experienced the corruption himself. The story is unbelievable. Look him up. It's mind-blowing what they did. It pissed him off. He is very, very smart. He has way more money than I did. He ran for sheriff at the last 3 months last year in 2016 and almost won. He got all of the black vote. And the reason why he did that is because he ran in, I will not bust, we're in Florida, I will not bust anybody for weed anymore unless it's an ungodly huge amount, like pounds. And then he also ran in, no more victimless crimes, no more of this freaking road pirate bull crap. And then he was going to cut the budget by 30%. And when you think about that, you can. If you stop the road pirates, you can get rid of a bunch of people. Gone. So, the wife has been saying, yes, I can, yes, I can't. So I don't know. We're trying to find somebody that can do it because I am busy doing this anyways. But, so I'm making a video, like I said, that $1 a month from everybody, you know, for 53,000 subscribers, that is not working. I'm just letting you guys know. Absolutely give way more than $1 a month. If you can, I appreciate anything. By the way, remember too, when you give that, PayPal takes like freaking 15 to 20%, so it's even worse than that. But, and there again, like I'm letting you guys know, it's way, what I get is very, very low. Appreciate it, but it is very, very low. Can't live on it. I'm just, you know, I'm working, and that's what I'm working on. And that court case is going to cost a buttload of money. That's federal court. Just the filing fees and the depositions that we're going to be doing with this corrupt cop. So there's another reason to give. We are going to be doing a deposition with this very corrupt. He was in a drug squad. He is a bad guy. He's on steroids. We heard steroids are rampant here. That's why their attitude is so bad. And we are going to get him on video, and it will be on YouTube. So that case alone is $5,000 just to bring it to court, and that's my money out of my pocket. So there's another reason to give, and give way more than $1 if you can. So keep that in mind. This is the new video, and I see, God, I talk a lot. It's already 7 minutes, but had to make it just to let you know the $1 a month from everybody is not working. They're not doing it. So if you can give more than that, please. So thanks. Keep it up. Share, like, subscribe, tell your friends, send me your videos on corruption, and I'll post it.